Is 10 o'clock, so we're going to go ahead and begin. So as everyone knows, this workshop is a continuation of a series of workshops that we've had to discuss the constitutional amendment that we're considering putting out to a vote to the BIA. We're going to vote on that on Tuesday. So we have Ryan Mills, our general counsel from our legal department. Ryan, could you give us a brief recap of our progress so far?
Yes. So the last couple workshops, we got through the powers and authority of all three separate branches, the legislative, the judicial, and the executive branch. We got through the Bill of Rights, and we got through a bunch of housekeeping things like changing membership to citizenship. But we got through at least the initial pass anyway of all the branches, how they would be structured and what their authority is. Today we have several articles to go through. I'm hoping some of them will be quick. But we have resignations, recalls, removals, and vacancies, nominations and elections, sovereign immunity, referendum, amendments, adoption, and then our bylaws. Those are the articles that we have not gone through. The bylaws are substantially as they are now, but there's going to be some tweaks to fit a three-branch government. But that's what I'm hoping we can get through today.
All right, sounds good. So let's get started where we left off, please.
All right, so we're on Article 9, resignation, recall, removal, and vacancies. This section will deal with how elected officials and appointed officials get recalled or removed, or if they step down, how we fill those vacancies. Section 1, resignation. Any appointed or elected official of the tribe may resign from their elected position, I should put track change down, sorry. Elected or appointed position by submitting written notice of resignation to the tribal council. Such resignation is effective upon receipt by the tribal council. I'll pause for a second. We discussed last time making sure that all these sections apply to appointed positions as well, so I'll make sure as we're going through this, make those changes. Pretty self-explanatory, that one. Section 2, recall. The registered voters of the tribe shall have the right to recall any elected official of the tribe by filing a recall petition with the Election Commission. The petition must meet the threshold number of signatures of registered voters as follows. A, recall petition of a tribal council member must have verified signatures of at least 10% of the voters registered with the voting unit that the council member represents. Apologies, we did a global change of citizen to member, but obviously this has to be member. B, the recall petition of the tribal Ogama must have verified signatures of at least 10% of the registered voters eligible to vote in an Ogama election. And C, recall petition of a tribal judge or appellate justice must have verified signatures of at least 10% of the registered voters eligible to vote in the election of judges and justices.
Ryan, if you don't mind pausing, Bridget has her hand up for a question or comment.
Ryan, I'm just wondering, since this was written, almost 20 years ago, and we've changed, our population is increased instrumentally in those last 20 years, should we decrease the percentage? Because, when you're talking, 36,000 people that can vote?
Yeah, so like
10% of that?
Yeah, for the tribal Ogama, let's just round it. By the time, it's probably 40,000 now. It's just shy of 40,000, right? So 10% for B would be 4,000 signatures. For the unit,
Yeah.
races, 10% might work. We'd have to look at all the numbers, but.
Yeah, I'm not just saying for the chair trying to, pick any fights. I'm just looking at what, if we can even look back to see what our number of voters were back when they wrote this to see. So, just a thought.
So
Thanks.
I agree with Bridget, 4,000 signatures isn't practical, but it shouldn't be a number that can easily be obtained over a weekend or a week either. Like if you're gonna overturn an election, with the recall petition, it has to, garner enough support to overrule an election. So is there a number or percentage that you can recommend, Ryan, that would be more in line with what our desire is here?
Well, if we take away, if we look back to the last election we had before we did automatic voter registration, we had about 16,000 registered voters. So 10% of that is 1,600, which maybe is a more manageable number. That would be 5%. That would be less than 5%, but 5% of our full 40,000 voting members would be 2,000 for Ogama. I'm not sure if I have a recommendation or what I think would be an appropriate amount. And I agree, Austin, it has to be a substantial threshold because we don't want a bunch of random recall petitions on any of our elected officials, but it has to be a threshold that is not so far out of reach.
Exactly.
I mean, 1,500 to 2,000 for a chairman, maybe that's reachable. I don't really know.
Okay. It has to be something heinous that would cause the recall, that would motivate enough people to want to sign it. Something
Yeah.
that would be an atypical situation. Aaron?
Yeah, so I appreciate the committee distinguishing the difference between recall and removal, because in the past, when they wrote this, it came at the tail end of I used to call it removal madness. I know I survived 8 removal petitions. Bernard survived like 6, and it took 100 signatures. And I know Bernard used to get 4,000 votes. I used to get 4,000 votes. You get about 4,000 votes. And then 100 signatures, when you get that many votes, is just nonsense.
Silly.
But I think that whatever the threshold is for the chair, it needs to be the same for the tribal board members. So this is not removal, this is recall. So this is the people are dissatisfied with how somebody's representing, and it should be their right to step forward to, to say, we made a mistake, we screwed up, we don't want this person anymore. So 10% of our smaller units is 40%, which is lower than what the Constitution used to say, because it used to be 100 signatures. So if then if you make that 5% of the smallest unit, then that's like, you just pee off one family and then there's a recall coming. So it should be substantial enough. The thresholds should be substantial enough that you have to work for it. The other thing is, it needs to be proportionate to the number of citizens. Because, 20 years ago, is it 20 years ago? Yeah, wow. 20 years ago, when the code changed from just 100 signatures to 10% of the signatures, we were probably 15,000 people less. So it needs to be proportionate to the number of citizens. So I don't know. I mean, I'm not proposing anything specific. But I don't think it should be so low that it becomes used as a tool again to disrupt government. It needs to have some purpose, but not just be, because like I'd say 80% of the removals that Bernard suffered through and all of the ones that I suffered through were frivolous, they were nonsense. It's cost the tribe a lot of money to go through all of this, and it was abused. And that's why the board changed it in 2004 to increase the threshold, but that was removal, not recall. So anyway, so I'm just weighing in on, it needs to be a significant percentage. It needs to be a percentage, I think. And I think whatever we do for the chair, we also do for the council, because the threshold shouldn't be easier to try to remove or recall the chair than it is to recall a tribal board member.
Do you guys want to circle back on this? Spend some time thinking about it? Okay.
Maybe after we look at removal, then recall will come into light better.
So Ryan, make note, this is one of the issues that we have to circle back on before we're finished with this draft.
And before we circle back, I'll try and pull up the numbers of like the different voting units, and we can kind of run some scenarios.
Maybe something after lunch, we can discuss this.
All right. An elected, we'll just skip the removal, or the recall, we'll go to removal, sorry. Section 3, removal, any appointed or elected official of the tribe may be subject to removal for any of the following reasons: gross misconduct or malfeasance in office, B, conviction while in office of a felony under federal, tribal, or state law, or conviction of any other crime involving dishonesty or moral turpitude, C, inability to fulfill the duties of the office due to mental or physical disability, to the extent that he or she is incapable of exercising judgment about or attending to the business of his, her office. So this, oh, sorry, I was going to point out, so this section in the 2008 draft had the 100 signatures that Director Payment alluded to earlier. So if you get 100 signatures, then you go to the trial court and you can start removal proceedings. This draft right now shoots mostly to our removal code, which would have to, of course, be updated to fit a three-branch government. But in our current language, we've spelled out some of the reasons we think that would be good cause that weren't defined in the 2008 draft, but then left the rest for legislation, is why this language looks like it does today.
Go ahead, Aaron.
So the first thing I think is that, and you just said it so it fits, is this should be, the section should read removal for cause, because in the past, again, the removal process was totally misused. And another thing that might surprise people is I was one of the loudest voices to say that when the board added the felony prohibition, that was done in 1998. And it was done to prevent a certain person from being able to run for office because the chair at the time knew that this person had a felony. Today, that felony would be a misdemeanor crime, not a significant crime. But it was put in the code in order to deny a particular person, which violates bill of attainder and ex post facto, which are violations of the U.S. Constitution. So I think it should be for cause. We should say it's for cause. But I do support Section B, as the committee recommended, which is a felony. The reason I didn't support it before is because the board shouldn't be able to pick and choose criteria to disqualify their opponents. And that's exactly why it was done, to disqualify an opponent. But if the people vote on, and we'd let the people make the decision, an amendment to the Constitution is a prohibition against a conviction, a felony conviction. The only thing I think I might want to add is, although it might fall under crime involving dishonesty, moral turpitude, I'm not sure, because that's interpretive, right? But if it's premised with the felony first, if that whole sentence starts with a felony for the following, but I think misappropriation of funds, breach of fiduciary duty, those are the types of things that I think you should be able to be removed for, because that's your primary duty, is your fiduciary duty. But a crime, not just an argument. The C I'm a little uncomfortable with, because who decides mental or physical disability? Is it the board decides the chairman is acting crazy? So then that's cause for removal. If this is adjudicated by the judiciary, I feel more comfortable with that than having the board decide that. Because if you were really probably in high school at the time all this craziness was going on, but it really came down to just total politics, and voting on removal or not voting on removal is depended on if you had your ducks in a row and if you were kissing butt to just enough people to protect you or to go after you. I mean, it was abused all the way around. So I think we just need to tighten up what removal for cause would look like. And I do support a felony, but I will support a felony only if the people vote to make that a prohibition.
And the way this would work, as substantially worded here, is it would have to shoot to our laws, which we have our removal ordinance for board members. So we'd have to, if this wasn't spelled out in the Constitution, it has to be spelled out in code. And so we'd have to, that's one of the ones we flagged previously of a code that it's gonna have to need to be revised anyway, no matter how we shake out our Constitution. If we separate in any form, we probably need to look at that chapter again. And right now, if we didn't change it, it would shoot to like that, we create that board, right, the removal hearing board, right? It could be our tribal court, but right now, it's not explicit in the Constitution, and it would all be reliant on the legislation.
Aaron?
So that's all the more the reason that it needs to be, the base premise and the parameters should be established in the Constitution, so the legislature cannot abuse their authority by writing a law that, if the Constitution's ambiguous, they could write a law that makes, if the chairman gets up and is angry and walks out of the meeting, that's removable. And so it's got to flow from the Constitution. So that makes this section even more important because our last general counsel kept punting everything to legislation, and that's too much power. We should not have an arbitrary and capricious decision-making at the legislative branch level without having a core set of principles in a constitution that sets the parameters. So it is too broad. I think it is too broad. The other thing I was going to circle back to with recall, and I know we're going to come back to it, is typically recalls aren't just you pee off a family member. They can go out and get signatures and then submit it, and then there's some process and you're removed. Recall is a vote. Recall leads to a vote. It leads to signature gathering, an argument case being made, and then the people deciding whether or not that cause exists to recall somebody, and not a group of 12 people sitting on the board, because I can see this being abused. If, we have an OGMA and we have 12 council members, council members not liking, let's say the OGMA vetoes something, the board votes on increasing their salary, doubles their salary. The OGMA vetoes it. The council gets mad that the OGMA vetoed their 100% salary increase, and then they establish some kind of a, and this has happened too, where board members have been in league with citizens to circulate removal petitions, or recall petitions in this case, or removal petitions, and then it comes back to just a sham of a process because they're serving their own self-interest, not serving the interest of the people. So recall should lead to a vote, and removal just needs to be tightened up.
Circle back on this, Aaron? Okay.
Are we going to circle back to removal?
It seems like Aaron would like to circle back to determine what kind of misdemeanors would warrant a removal. Am I hearing that correct, Aaron? In addition to that, what kind of criteria would have to be met if someone's having, mental deficiencies that wouldn't allow them to meet the needs of their office?
I didn't
or get rid-
suggest misdemeanors. I didn't suggest misdemeanors at all. I suggested that crimes that are like breach of fiduciary duty or embezzlement, to me, if you create an embezzlement situation, you should never be able to serve on our board.
Okay, so what kind of crimes would prohibit someone from serving?
Yeah.
And then do you have any other suggestions that we should circle back on, Aaron?
I think that moral turpitude might be too ambiguous, because I don't want to leave it up to a council to enact what moral turpitude would look like. What I think is a violation of moral turpitude, which infidelity is one of those for me. I was raised very strictly in my family. If you lie to the person that you're sleeping next to, how can you be trusted at all? But obviously that hasn't been a standard that's been followed at all in our tribe. Or dishonesty is too, but again, if it's premised on a crime, if it's a conviction. But here's one of the things that, where we did clarify, when we first got established our gaming commission, people that had certain convictions that were not felony convictions for not acts of dishonesty, but like writing bad checks. We ended up changing the law there because we found that to be too restrictive. And I guess I believe with that, although I've never written a bad check. So I just think we need to be more clear about what in the Constitution, the legislature can then write laws to comport with the Constitution and not go beyond what the Constitution says. So,
Yeah, so I think maybe one thing to consider is fleshing out B more in the sense that we enumerate the crimes that the majority can agree that should be in the Constitution. You maybe eliminate C. That was language pulled from other tribal constitutions that have separated powers, but as I'm sitting here and we're talking, it is too broad, and it would leave a lot to legislation. So maybe you eliminate C, you flesh out B, and then the codes that are later enacted are gonna have to be in line, right, with those strict reading of the Constitution if we enumerate the crimes that would be subject to removal.
I just thought of some other thing that supports eliminating C, is we have had situations, I won't name any names, but we have had one situation where a council member was made disabled through a medical situation, and we didn't know for a long time whether or not that person was going to be able to come back, and we carried that person as a tribe, right? So under this, that person would be subject to removal. We've had several board members that have had cancer at different times, some who have not shown up to do their job here because they were really, really sick. And this could cause them to go right for removal just because they're sick. I would think that would be a little more compassionate than that, to immediately try to remove them.
I can think of Denny, you know what I mean? So I agree with you, Aaron.
Sorry, do we want to workshop B, or do we want to circle back to this? Like, do we want to figure out some other crimes we want to maybe put in here and then pull it, or do we want to?
I would say crimes against children as well. I mean, we can talk the talk about, missing and murdered children, but, I mean, if you have a major crime against a child, whether it's a sexual abuse crime or something along those lines, I think that should be disqualifying as well. You can make an argument that, extreme cases of domestic violence against women too. Like, we always talk about missing and murdered Indigenous women, but, the ugly truth is a lot of times the perpetrators are Native American men.
I can see that.
Can anyone think of any other crimes? I mean, so it'd be financial, violent crimes against persons. Mostly for women and children. Like if someone got in a bar fight years ago, who cares? You know what I mean? Like that's different than, okay, I abused a woman or a child. Does anyone disagree with me on that front?
The difference with what we're doing here is we're proposing to the membership to establish that, and we would be amending the Constitution, which is the correct way to do it. In the past, it was all discretionary up to the legislature to enact how to deny their opponents from being able to run against them.
And the violent crimes against persons brings us constitutionally, if it gets adopted, in line with our policies. We have that in our child background check for a lot of our covered positions, and an elected official, maybe they're not a covered position, but maybe they should be held to a similar standard, right?
And the crimes against persons is not something we just made up. It's actually a stipulation for our funding requirements and crimes against children. I can remember when we had to fight that fight, because we had people that had crimes against children that were working in the YEA program.
As long as it reaches a certain threshold, like again, like a bar fight example, when you're 21, I mean, does that really disqualify you from serving on your council if you're 40, 50, you've been sober for years, or just a dumb misunderstanding, you know? Mike, then Tyler.
I think one of the things we gotta note here, though, is we're talking about two different things. We're talking about removal, but then we're also talking about eligibility to run. So right now, we're talking about removal things. So all the things listed right here so far, I'm 100% in agreement. But then when we're talking about eligibility, that's a different subject altogether. We've already went through that, so it sounds like we're revisiting it. Because when we're saying things like getting on committees and whatnot, you know, those same standards. So that leads me to believe that we're having two different discussions here. So,
Because, yeah, you're right.
So
Mike,
would
'cause
this
felony-
mean-
Felony is the prohibition, full stop, and we don't clarify further.
So Ryan, if we're talking about removal for cause, then would this be while a sitting board member, Ogama, gets convicted for this stuff?
yes.
Okay, good catch, Mike.
Yeah.
Right, and so you could just leave it as conviction while in office of a felony under federal, tribal, or state law, stop, and then that would kind of mirror the language of the eligibility requirements that you have in the legislative, in all three branches. You have the felony.
I'm more okay with having an expanded removal process
And then
than
mirror
the
that language
eligibility,
above.
because if that's gonna flush itself out during elections, and people are gonna know what happens, and if they wanna elect somebody that's that, then that's what's going to happen. The felony prohibition, if we leave that in, then we leave that in, but all the rest of the stuff, I think, gets really, really sticky, because being on the election committee for 17 years, there was instances where we had to tell an elder that, hey, guess what, you can't run because there was a shoplifting conviction, when we had that prohibition on misdemeanors involving gambling, theft, or dishonesty. And he didn't even realize he had it. It was, 50-plus years ago, and he was 17 when it happened, so it was on his record, and he couldn't run, and I don't think that should have been a thing that prohibited him from running. So I'm okay with it not being on the eligibility to run, but I'm more okay if he does it while he's sitting in office and he's stealing or something like that, and then they get caught stealing, well, then, let the people decide on the recall, so. But we were having two discussions, and I just want to
We
make
were,
sure we're
yeah.
all on the same page.
Appreciate that. Tyler?
No, Mike hit my point, and then Ryan clarified with felonies, state or federal. So I think that's fine. Because my concern was you're talking about the difference between a bar fight and domestic violence or whatever. But that would then need to be fully clarified, and I think Ryan's language just fixes that.
Okay. All right, so just to provide clarification, what we're talking about right now is removal for cause. So if a sitting board member, Ogama, is convicted for any of the following things that we've listed, they'd be eligible for removal. So right now, what we have is convictions while in office of a felony under federal, tribal, or state law, or conviction of similar crime involving financial fraud, violent crimes against persons, and that's what we have so far. Aaron?
All right, so I'm thinking about this I might be able to be talked into this, all right, so again, I have a conservative background, that's the way I was raised, and that sticks with you, and the older you get, you come back to the way you were originally raised, right? And the thing is we have a lot of tribal members, and one of the arguments I made in the past is why do we want to qualify somebody who has a felony conviction when we have a lot of honest people who've never committed crimes? And I know also there's victims of circumstance. When I was homeless, I stole all the time for food. That's how I fed myself. I never got caught though. But, and also before, I bristled at the notion of just the board creating criteria to prevent to restrict opposition. Because I can tell you, I can guarantee you, I can point to it, give you specifics on why this was put in place in code, not in the Constitution. And it happened in 1998 to deny a specific individual from being able to run from office. But I do think, if you look across the states, we have a U.S. Constitution, we have the requirements in the U.S. Constitution, but we do also have, at the state level, criteria for running for office, and I think half of the states do have a felony prohibition from being able to run for office, and some even have prohibitions from being able to vote. We don't have that, I don't support that. So I don't want to throw the baby out with the bath, and Mike's right that this is a separate section than eligibility, but I think if you have a felony conviction, I think that the people of the tribe should be able to vote on whether or not, in a constitutional vote, on whether or not they want that to be a restriction. Because there is a lot of our members who believe that a felony should be the dividing line to run for office, because we do have a lot of people who've never been in trouble before. So, that's it.
Okay. Well, before we're done with this, let's circle back to eligibility to run. It'll be a refresher of what we decided, and then if there's majority consensus to change that, we can do so.
Well, I guess one final thing is I do agree with what Mike said, that if it doesn't rise to a crime, it should be a crime, a felony crime, that prohibits you from running, we could still have cause for removal that removes you, but then let the people decide whether or not they want to return you to office. And I use the example of, because we fixed this, or you guys fixed this before I came back, used to be that if you had any conviction and a board member got removed for possession of a small amount of marijuana, who she argued was somebody else's medical marijuana, and some people were frothing at the mouth to remove that person. And now we're partnered with pot. I mean,
Kinda
we're
stupid,
right in the
right?
business of it
Yeah.
now. And so, and we have fixed that because that person is now eligible to run, because we eliminated that restriction. But that was, again, the board voting to create that restriction to reduce their competition. And I don't like that kind of abuse. So whatever we do in the Constitution, with a separation of powers, we will finally have the ability, if the legislature tries to pass a law that is not consistent with the Constitution, it can be overturned by the judiciary. And that's the proper way to operate as a government, not pass laws to restrict your competition. So,
All right, let's keep moving then, Ryan.
All right, we'll circle, let me make a note. We're gonna circle back more on this, circle back. Section 4, vacancies. A vacancy in the office of an elected official resulting from death, resignation, removal or recall shall be filled by a special election held after 30 days but no more than 90 days of the vacancy. If 6 months or less remain in the official's term, then the seat shall remain vacant and shall be filled in the next election. No, go ahead, I'll pause.
Go ahead, Aaron.
just going to say that, so when this was written, if this is substantially consistent with what the committee came up with?
Yeah.
Okay. We would have, at that point, had a resignation from a chairman, because Joe Lumsden had cancer and resigned, and the board voted to make the vice chair the chair at the time. But this has been abused, in my opinion, and I think in the opinion of a lot of the members over the years, because when Joe McCoy resigned, the people wanted a special advisory election. The board refused to do it. And a really good person, somebody who's one of my friends, he's deceased now, was appointed, and then 2 years later ran, and I ran against him, and he lost by almost 1,200 votes. And I think in part because people had, confidence in me as a candidate, but I think also because people did not like the board making an appointment without an election. And so that's one example. The other example is in the last, when I resigned, the board made an appointment after the incumbents lost. They scheduled a special meeting. They made an appointment for somebody who couldn't even clear his primary to get reelected. So, if you ask yourself, what's the will of the people was not to appoint that person. But the board did it anyway and argued that they couldn't have a special advisory, used legal arguments, but they they had a house of cards. That argument was made on a house of cards by saying, well, we can't have an election during an election. Well, that's true, but you could have left the position vacant and then scheduled an election to happen subsequent to that. But instead, a group, jumped the gun. 6 people who lost their elections voted to appoint somebody who the people didn't want. And so here's the thing, all right, so it could be argued, well, yeah, they did, sure they did. But then we had an advisory election, and the people made clear they did not want that person. And part of it might have been they didn't want that person individually, but part of it might have also been that they didn't appreciate that choice being taken away from them, the voters being taken away from them. And so the people voted, again, overwhelmingly to elect somebody other than who the board appointed. And so the decision of a council to appoint somebody to fill a vacancy is not supported by the membership. It should be clear by now, time and time again, when the board has failed to hold a special advisory, and then the people get to weigh in on that, and those elections haven't even been close. So the people have affirmed that they want the right to select their elected official. And because the Constitution currently says that the board shall make an appointment, this is our chance to modify that and require an election so that it has to happen. So the board, a sitting board can't make the decision, especially, and you alluded to it a couple of weeks ago when we were meeting, is if, let's say, especially like with the concept of the speaker becoming the chair, the legislature can orchestrate a removal process, compel the removal of the chairperson, appoint the speaker. Sounds familiar, right? And you hit the nail on the head when you said it last time, and it shouldn't be that way. The people should be the ones who decide who their ogima is and who their council is, and not a faction, a political faction of board members. They should not be able to make that decision.
So, quick area that I'd like clarified, Ryan, before I call on Mike. So it says here, if there is a resignation, removal, recall, there's going to be a special election, right? But if it's 6 months or less from the next election, there won't be, that seat will be filled at that election. Does it give the board the ability to appoint anyone? Legislative branch, whatever we're calling that.
Right now, not to appoint someone, but there is further down, depending on what office is vacated. Like right now, the language is from the 2008 draft for ogama. If that seat is vacant, then the speaker steps up. If it's a chief judge or justice, then the next senior justice or judge steps up. And then the only appointment right now, as worded, is if there's a vacancy in the speaker, then the tribal council can nominate someone from their body to be the new speaker until that seat is filled. Otherwise, it's kind of, there's like a succession plan built in.
Okay.
But right now, they wouldn't be able to just like, besides the speaker, the council wouldn't be able to just seat someone in the ogama seat. If it's not the speaker or the vice ogama, if we change it to be that, then it's just whoever wins the election.
Okay, go ahead, Mike.
All right, I wholeheartedly 100% agree with putting a special election in the Constitution. I am going to speak up though every single time it gets brought up that like previous stuff that we had a choice. There was no choice. We followed the law. If people don't want us to follow the law, then we should change the law. But there's a constitution in place that said that the board had to appoint someone, and there was laws prohibiting a special election at that time. So we followed the law. So it can be stated, and it has been stated 100 times, but I will bring it back up 101 more times, that we followed the law. Whether people liked what we did or didn't do, that's subject to opinion, and you can have your opinion on that. But to sit there and say that we had options, I think is disingenuous. I think that we had to follow the law. We followed the law that was there. Could we have arguably changed the law midsection? Maybe, but I don't think that's good governance either. Changing the laws and the codes while we're doing it isn't good governance. And that's been done several times in the past. So the laws were on the books, we followed the laws, and I don't want to rehash it up, but it's getting brought up and asserted that we had options, so I'm just going to point it out. And if I have to point it out every single time, I will every single time. And as I said before, there's difference of opinions on who and all that, but at the end of the day, there was the law and we followed it, so.
Aaron?
Yeah, so I saw the video, because it was leaked, of the meeting where the council met with legal counsel. And I watched the tone and tenor of board members browbeating legal counsel and basically telling legal counsel, every time the question was asked, it was turned back around to, no, that answer's not right. Here's what we want. Here's what we want. At no point on that video or in any written legal opinion from general counsel at the time did the council say the board was required to make an appointment. The option was, and this has happened before, when Joe McCoy resigned from office, the board waited for almost 2 years, a year and a half, before they made an appointment. And they appointed Joe Eitram at the time. So that completely dispels the notion that the board was required to make an appointment. If you go back, and I'll ask for this legal opinion, at any point did general counsel at the time tell the board that they were required to make an appointment? Because that's not correct. The board chose to make an appointment, and they scheduled a special meeting such that the 6 board members, who 5 and 1 retired, could help make the choice to make an appointment under the, well, I won't say under the cover of darkness, because I got me in trouble before, but without the will of the people. And actually in contravention and opposition to the will of the people, because the appointment they made was with somebody the people just rejected in a primary. And so, unless there's something that came from legal that advised the board that they were required to make an appointment, the correct process would have been to allow that time period to come and go and lapse, and then schedule a special election, even at the first meeting after the 6 left office. The people did not appreciate that, and you're right, people will have an opinion and they'll vote based on their opinion. The other thing is that whether or not it's right or wrong, this was tested in the courts, and the court determined that the board made the wrong decision. So the court upheld when the board voted to vacate that appointment, because the board correctly vacated that appointment because it was done improperly, the court upheld that decision. And I suppose we can get into a legal argument back and forth if that's really what they did, or, but the court upheld it. And then we had a special advisory election after that, and the people reaffirmed that they believed the board made the wrong choice. So here's the thing. I don't bring it up to rub salt in the wounds or, try to insult the board members that did that. I bring it up because we need to reform our government so this cannot happen again. It should not be allowed to happen again. And I am formally asking for a legal opinion about whether general counsel at the time advised the board that they were required to make an appointment and that they didn't have the option of letting the seat sit vacant until a special advisory was called.
So what would we have to have in this Constitution to prevent something like that from happening, Ryan? That way there is a special election. That way elections decide who is seated rather than politics at this level or whatever.
So as worded right now, setting aside our discussion on if the speaker is appropriate to fill in for Ogama, the way that the Constitution Amendment is structured right now, it does not give the legislature the ability to set any appointments like that, and it would go right to the special election within that 90-day
The issue is, though, that you would have a speaker, that would be next in line with that secession plan, and that's why we had such a vigorous debate when it came to a vice Ogama. That way there'd be a clear distinction between the two branches of government. That way you can't have a small threshold of signatures for either a recall, you can't have politics motivate a removal, and then have a legislative body select who their speaker is to assume that role, even if it's for 90 days. You know what I mean? Like, you can get political momentum in 90 days. You can undo a lot of things. You can do a lot of bad things in 90 days. So, I mean, that was one of the things that we highlighted that we need to circle back on. And I truly believe if we're going to have 3 separate but equal branches of government, there can't be any blurred lines. There really shouldn't be.
So yeah, so if we, sorry, no, Aaron. I'll just respond to that real quick and then, so yeah, if we figure out how to address that issue that we put a pin in for now, the rest of the language and the current amendments substantially would cover that basis. So once we figure out what we want to do, if the OGMA is vacant, the rest of this does not allow for any kind of appointments. It shoots that special election, or the seat has to be vacant until that election
The way it would work,
happens,
again,
right?
you know, an Ogama would run with a running mate, and the tribal citizens would know in the event that something happens to the Ogama, this is the number 2, and it would just eliminate the possibility of political games, because that's what we want to get away from. The political games, politics, just distinct lines, separation between these branches to where politics can't infiltrate them. Aaron?
So, again, and what we should be about doing is reforming our government that transcends anybody who's sitting in office right now. And rather than be defensive about what structure we need to create, or, you know, imagining, well, we would never do that. I don't know if it's in our nature, if it's our way, but if we go back to prior to 2004, which means none of the current council members, so nobody has to own this, we went through, in the period of 3 years, we went through, I think, I went through 8, Bernard went through 6, Lumsden went through 4. So what is that, 12, 18 removal processes within the period of about 2.5 years. And it was totally abused. It was all made up. Now, flash forward, in January of 2022, there was a censure of the chairperson with allegations. There was consequences without any evidence supplied. There was an investigation that dismissed every single one of the allegations. And I bring that up because there was a removal petition that was identical. And I'm not talking like similar, I'm talking identical, verbatim, to the censure document. And so I'm not going to imply that board members were colluding with the removal petitioner, but if it's possible for us to orchestrate removals and to work to undermine our democracy by not, if we don't like the chairperson, we don't like a decision the chairperson's making, the legislature in the new structure could vote on a censure, and then a petition could circulate that's identical verbatim to that, and then remove the chairperson, and the speaker becomes the chairperson. And that's a problem. That's a really big problem, because that is just totally piercing any notion of a separation of powers, because it's handpicking, a group of 12 people handpicking who their chairperson is going to be. And if they don't like the OGMA, they don't like the OGMA's decisions, they can just orchestrate a process to remove the OGMA and appoint who they want. And that is a total abuse of power. So.
Okay, we can keep going now, Ryan.
All right. I'll go through assumption of duties as it's currently written. In the case of a vacancy in the office of OGMA, the Speaker of the Tribal Council shall temporarily assume such duties until the results of the special election are certified and an successor sworn in. 2, in the case of a vacancy in the office of Chief Judge or Justice, the Senior Associate Judge or Justice shall temporarily assume such duties until the results of the special election are certified and a successor sworn in. And 3, a vacancy occurring in the position of Speaker of the Tribal Council shall be filled by majority vote of the Tribal Council. So that is the assumption of duties as currently written. I think, I'm hoping, at least for the judge, that would make sense. We can get agreement on that. And maybe also for 3, the Speaker, if that's vacated, they can fill that with another seated Tribal Council member. So our sticking point will be little I there, vacancy of OGMA, which is what we talked about several weeks ago, and we'll have to get majority consensus on where we want to go. Last time we polled this, the vote was very close. I think it was 6-5 or 7-6 to keep it as Speaker, but there was lots, as you said, Austin, robust discussion, and we put a pin in it for further workshopping.
Well, let's have a talk about it now, because we have a long list of things that we have to circle back on, and it seems like we need to address some of this stuff right now. So this is about the succession plan for the OGMA. So the OGMA will be in charge of the executive branch of government, but if there's a removal, death, resignation, recall, and that person leaves office, currently the person that would take over would be the speaker, who would be a member of the legislative body, which is what the board would become. So my concern is, if we're gonna have separate but equal branches of government, then you have to have a plan B in the executive branch, and that would be a vice OGMA. So that's the structure with state government, all 50 governments within our country. That's the structure in the United States. And in my opinion, it just forms a more concrete separation between the branches of government. So politics happen, you know. Out of the last 3 chairmen, myself included, you had 2 resignations, and we want to get away from someone non-elected to that position sitting in that position. So if you have a vice OGMA that would run as a running mate with the OGMA, you know, the tribal citizens would vote for that ticket, with the understanding that if something happens to the OGMA, the vice OGMA would assume those duties. So let's have a discussion about this. After the discussion, we'll poll, and it will be where it is. But again, if you want to have separate but equal branches of government, you have to have this distinction. So, Aaron.
Yeah, so one board member was not here because of a family situation, and that's actually Kim. And so if we talk about the fundamentals of a separation of powers, it makes no sense that somebody that's elected to the legislative branch gets to magically become the chairperson. Just like it doesn't make any sense for the board to appoint somebody without the will of the people being behind it. Every time that, with the exception of Bernard, when Bernard was appointed, when Joe Lumsden resigned because he had cancer, the next time Bernard ran, he won the election. But every other appointment that was made, the person has failed to become reelected. And I'm not picking on Joe McCoy or Joe Atrum or somebody else, but the people in all 3 situations rejected the decision of the council to select who the chairperson is, because the people do not appreciate the legislature or a faction of the legislature making the decision of who is elected to represent all the people across the tribe. So, so I asked a couple of committee members, how is it that they had conversations about a vice OGMA all the way through the process, but in the end, it didn't make it into the document. And what I was told, and again, this can be disputed by several committee members, is that there were poison pills put in by some members of the committee that knew when the draft would go out as written that it would fail, and that was by design. So like, you know, tomorrow night we're going to vote on whether or not to put the original draft out, which has Mackinac Band, it's got at-large representation, it's got all this stuff in it that will probably cause it to fail. So what Kim didn't get a chance, Director Hempton didn't get a chance to weigh in on was whether or not the Speaker of the legislative branch should be able to become the OGMA without a vote of the people. And I think that that's an abuse. I think that's, it doesn't comport at all with the separation of powers. Because even if it's a temporary appointment, they can do a lot of damage temporarily to set the structure up to weaken the executive branch and strengthen the legislative branch. So like if the Speaker becomes the executive for a period of time, they can do a whole bunch of damage in the meantime and then go right back to the legislative branch. And that would be to dismantle or to weaken the executive branch. So the solution is not to appoint the Speaker to become OGMA. The solution is to have somebody who's elected for the purpose to step up in the event that we have a vacancy in the OGMA seat, and that is a vice OGMA. So I know it's a departure from what the committee came up with, and I know it's a big step. Maybe it won't happen in this step, but I don't support at all the Speaker becoming the OGMA without a vote of the people, even for a temporary arrangement. I don't support that at all. And the reason for that is, again, you know, the saying, 3 strikes and you're out. 3 times the board in the past, this current board and a past board, not including any of the current board, well, maybe one board member, appointments have been made and the people have subsequently voted and said, no, you made the wrong choice. That's our choice to make, not a faction of the board.
Lana, then Bridget.
Yeah. Um, well, yeah, this is the one we were gonna circle back to because there was a lot of discussion on it, and I'm sure that all of us have spoken to past committee members and had their thoughts on it, as well as current tribal members. So this would be, this would be a major change, and I have lots of opinions about it, and I've spoken to lots of people about it, some that are here today and some that aren't. And for whatever reason, and it can be debated what I say or what any board member says on what their opinion was, but they didn't have a vice Ogima in the original Constitution. For whatever reason, we don't know that reason because none of them are here at the table. So, and if they are, they're not speaking up. So, this would be a major change. So I think in this document, what their intent was is to put a temporary speaker in place with a timeline stating that it can't go on forever. It can't be abused. When I'm done talking, I'll ask Ryan a point blank question. Is there a timeline to secure that it can't go on, that the speaker be the chair? Because we can talk about all kinds of things that happened in the past, but they did talk about those things. So, because I don't support, and I'll poll, I don't support a vice Ogima, because that does change the entire, that as a major change. So, and, here nor there, I mean, I'll either be in the majority or the minority on this document. So, Ryan, in this document, they put in place, just so the members online now and on live can see, they put in place in this document that with a vacancy of the Ogima, the Speaker of the House would take over for a temporary period of time, and in this document, things will happen within a timeline to secure that there's something triggered in order for an election for a Ogima, correct?
Correct. So in the 2008 draft, the speaker stepped up and assumed that office until the successor was sworn in as a result of that special election.
And how long before that special, I mean, I'm looking at it right now, but there is a timeline for when it has to occur.
Yeah, so in the current draft, all the vacancy elections have to occur within 90 days. In the 2008 draft, there was a range, 60 days for Ogama, up to 120 days for a tribal council member. Our draft set it at 90, the maximum, between 30 and 90 days for all the positions to make it more uniform. We thought 120 would be too long to be sitting there without having the voice of the people heard. But certainly the 2008 draft had an even quicker timeline of 60 days for the Ogama, which we can discuss too.
Okay, so right now, if our chairperson were to resign and we had a speaker, that speaker could only take over for a 3-month period and there would be an election. That's what this document would do right now.
That's correct.
Okay, thank you.
Okay, Bridget, then Aaron.
Yeah, along those lines, I don't, I support what was originally in there for that, if we can fill that vacancy within the 90 days. But, I don't even want to say this because I feel like fights get started, but I think we're wasting everyone's time to talk about why someone might have not got elected or what they did. I mean, that really doesn't have any place in what we're talking about here, so we could speed things up if we don't rehash why somebody thinks this person, that person, why it didn't happen. Just, try to leave that out so we can get through the day. Thank you.
Aaron.
So I think it is relevant, and I'm hoping the members are watching this because to ignore the will of the people and make decisions under this notion that we're representative, and therefore, once you elect us, we get to make whatever decisions we want, and hell be damned, it doesn't matter what you think after that. It does matter, because we are entrusted with the sacred responsibility. These seats are not ours permanently, and the tribe will exist long after the current board members and chairman are here. And what we need to be doing is writing a constitution that can transcend the people that are sitting here today. And so these are not irrelevant, they're not dilatory. It may rub people the wrong way, especially if they made decisions contrary to what the people wanted. But it's important for us to use our example of what has happened in the past so that we can write a constitution that can prevent it from happening again. So I do think that that's critically important. It's not a waste of our time. We're paid very, very well to do our job. So I also want to say that this notion that we're making major changes to what the original draft looked like, and I said this last time, and I want to be careful that we're not talking out of both sides of our mouth, because the fact that we're even reviewing this right now is because there's a principal belief, number one, that a wholesale rewrite is not tenable. Some board members have made it very clear that they will not move forward on anything if we're doing a wholesale rewrite. And so a year ago, we came to the conclusion that we could consider individual amendments, and that's what we're doing, right? And so if this notion of this purity to what the committee originally came up with, we are far past that now. We are now writing a constitution based on our professional opinion about whether something is feasible or not. And so this notion of a speaker piercing the separation of powers, which we have to believe by the vote that just happened, that the people don't want that line to be bled anymore, that they want a clear separation of powers, they want to elect their ogima, they don't want a faction of the board to make those choices, says to us that the appointment of a speaker is not tenable. It's not what the people want. Now, having said that, if I'm on the short side of the stick on this and a majority power it through, because that's what they want, if we could at least restrict what the speaker can do as the ogama on a temporary basis so that they can't make fundamental changes. Like, what I'm worried about is the speaker becoming the
fire
ogama,
staff?
firing staff, creating a liability for the tribe. And again, board members will say, why are we bringing up the past? Well, what happened when I left office in '08 is a whole lot of people were fired, people that had contracts, and we paid out well over a couple of $1 million in breached contracts that the tribe had to pay out. Several people were fired without cause, and they had contracts that required them to be paid out if you fire them for any other reason other than death or felony. And the board created a liability at that point. Hell be damned, it wasn't coming out of their pocket, but it cost the tribe millions and millions and millions of dollars. The general counsel was one example of who got fired. And I shouldn't have looked over at you when I said that, but, and that cost us $600,000 for the privilege of just firing the general counsel. And there was arguments made for moral turpitude. Who decides moral turpitude? I certainly don't want somebody to decide moral turpitude against me of somebody who's of questionable moral turpitude. I don't think that's their place. So I do think it's relevant for us. So if we muscle through this and the majority forces it, and we don't have a vice ogima to take the place, which the people would elect that person to step up in the event of a vacancy, so that would be the will of the people, then we need to put something in this Constitution that limits the authority of the speaker who's temporarily the chairperson or the ogima, so that they can't create a liability for the tribe, they can't undermine and disrupt the structure that was created by that ogima. So that's it.
The one thing you missed, Aaron, if you substitute speaker with vice ogama, it's still a temporary position for 3 months. So it isn't okay, a ticket gets elected, ogama resigns the day after the election, then the vice ogama has almost 4 years to serve. It would still be 90 days. The difference would be the members would elect that person as the number 2 instead of the board. So Mike, Kim, then Lana.
Well, two things, I guess, is one is that we're discussing language here that prevents a lot of the things that are being brought up. I think that's what Director Sorensen was getting at, is that this vacancy, this constitution has built in, hey, you're gonna have a special election. Our previous constitution didn't have that. So this is a big plus, and this will help prevent much of that. I think the big argument having the sub-OGMA, though, is that do we need another position embedded into the Constitution for 4 years at a time to prevent something that might be problematic for 3 months that rarely happens? And there's an argument to say about how rare that is, but I think under a new Constitution and new separation of powers, I do think it will be more rare. I think Director Payman said it before, this has been abused in the past, so having the separation of powers and built into the Constitution will help prevent a lot of that. And so the argument of, hey, do we need a sub-OGMA, just boils down to, I don't disagree with the notion of it, but having a position on there for 4 years for something that, to prevent some abuse for 3 months. And the abuse conversation, I think, can be applied to anybody anyways at any given time. That's the whole notion of having a separation of powers. Abuse can happen, and it's still going to happen, but having the separation of powers makes it where we can address it. So I'm still not sold on the sub-OGMA. I'm open to listening, but I do think that it wasn't in the original, so it's not just a majority trying to power something through. I think you have a whole Constitution Committee, too, that didn't put it in there. If it wasn't for a 4-year term to prevent some possible misabuse for three months on something that, like any given OGMA and sub-OGMA coming in can do that. They could fire people, they could do all that stuff. Our laws, I think, need to be reinforced, and that's on us. We need to have better prevention laws, and I think that's going to come into play with all this. I think that's one of the things that needs to be highlighted for us to address after the separation of powers all goes through, is we need stronger employment laws to prevent stuff coming, like incoming OGMAs coming in. They can't just wipe out the executive, all the people. So I don't think, I'm not sold. So I'm open to listening, but I'm still not there. I would still vote not to have
I paid
it.
for a couple.
And I'll yield up.
Kim, Lana, Rob, Aaron.
So I just wanted to clarify, Ryan, that in the case that the OGMA would resign, it says a special election will be held after 30 days, but no more than 90 days. So, I mean, worst case scenario, a special election could be held at day 89, and then the speaker from the legislative branch could potentially be in there for longer than 90 days.
Potentially, yeah.
Okay. I can see both sides of the argument. However, for me, I think it boils down to, it doesn't matter if somebody from a legislative branch is to fill in the executive branch. It doesn't matter if they keep the integrity of the executive branch intact, or if they are going to crumble the integrity of the executive branch. It doesn't matter if they don't need 30 days, they don't need 90 days, they would do it no matter what. To me, it's almost like a potential conflict of interest. Just taking somebody from a completely different branch, having them go into a completely different branch, and like I said, it doesn't matter what their intentions are, if it's going to be to keep the integrity intact or to crumble the integrity. I still think it's a conflict of interest, and then, yeah, I just think it's a conflict of interest, so I believe I go with the vice OGMA. So I just wanted to say that. I just think that would be more representative of what the people want, because they would have an input on that vice OGMA. If a speaker from the legislative branch moved into the executive temporarily, doesn't matter if it's 29 days or 99 days, ultimately, even though it's temporary, our people did not choose to have that person as part of it, the executive branch. So, thank you.
Lana, Rob, Aaron.
Yeah. I took a whole bunch of notes, but after you calm down for a little bit, I don't have to say it all, but I will say that, in the past is the past, but the buzzwords that are being used about trying to keep the will of the Constitution in its purity. I said it, I don't know how many times, I think Director McGrory said it a few times. We are gonna point out when there's major changes, in our opinion, whether it's valid, whether it's worthy, whether it's accepted. We have those opportunities to say what is a major change and what isn't. We're trying to get to a place, and true enough, this document is being rewritten by the existing board. So we have all opinions on our experiences through sitting here in these seats. Cause I could talk about a bunch of stuff in the past too, and all the contracts. Some of the people sitting at the table have had those contracts we're talking about. Some of them voted on those. So, this history lesson, we all have some history, on what happened. But I completely agree with Mike, on the comments that he said. Um, you know, and I think the chair brought up, that the speaker could, terminate all the executives. Well, so could the vice Ogima. I mean, I've seen tribes where there is running mates and there's a Ogima and a vice Ogima, and those two collide and they clash and they become a faction with the legislative. And I mean, anything can happen. So, we can have all of our arguments, but this is where we get to say what we think about this document, right or wrong, if we agree or not. So, I got a whole bunch of notes, but I'm just gonna leave it at that. And, I just needed to say that. Thanks.
Rob, Aaron, Tyler, and then I don't have any more hands. If you guys don't mind, I'll speak, and then we poll, and then we'll have some area of direction for this document before lunch. Are there no objections to that? Okay, so I'm not gonna add anyone else to the speaker list then, per that. Go ahead, Rob, Aaron, Tyler.
So I was not completely sold on having a vice Ogima, and I think there's probably some reason it was left out of here. But I am 100% not in support of having anyone from the legislature move over into the executive branch. And I'm really glad that that Kim and Lana spoke before me, because they both said a couple things that give me a little bit better insight. Director Hampton's main point is probably going to sway my decision on this, in stating that at the end of the day, with a vice Ogama, at least the members chose it. And I think that's going to be my sticking point, that at least the members chose that and knew that that would happen if something happened with the Ogama and they had to step up. I can never support putting anyone in that seat that the members didn't specifically place there, or at least know that there was a potential that they were placing them there with their vote. So I was one that wanted to look for another solution, that we didn't place anyone from the legislative over in the executive, and we didn't have a vice Ogima. But if these are the two choices, then I have to go with the one that empowers the members to make the choice.
Aaron, then Tyler.
Yeah, so I can respect board members having a different position than me. I've had to learn to do that over the years, because that seems to be the case. But also, I want to say this very clearly. My position on stuff is no less important, and I'm never going to be browbeat out of having my position, whether it's a direct attack on my position, or if it's some, with a pretty package to say, that's dismissive of my position. I have a graduate degree in governance, and I have more experience in tribal governance than anybody else on this board. And I've seen things that have happened over the years that are not consistent with what the people want, that we need to establish a constitution that can transcend individual politics and individual eras of politics and factions on the board. I'm glad Kim, the one statement she made that just makes it crystal clear why the speaker should never become the OGMA by an appointment of a separate branch is the conflict of interest. It is 100% a conflict of interest. And when you know that, when you know better, you need to do better. And now that we have that understanding, then we can't just move forward with having the speaker become the OGMA. It is a conflict. It's piercing the separation of powers. And the people just made it clear what they want. There's still some people that are hanging on this notion of a two-branch, which would not have an executive branch, but that isn't what the people wanted. Only 25% of the people suggested that that was tenable, that was acceptable, only 25%. And again, because I know this argument will probably come up today or tomorrow, the argument that, only a small fraction of our people voted or participated in the poll and therefore it's invalid. Well, you know what? A lot more people registered an opinion on that poll than most of the people on this board ever got in terms of votes. And so if the number of votes of 400 or 600 or 800 or even 1,200 is not sufficient, then they're illegitimizing their own positions. So I also finally want to say that an appointment of a speaker, especially if the speaker turns out to be somebody who's from a unit where only 400 people voted for them, when it takes 4,000 votes to become chairperson, or in the case if they run as running mates, the chair and vice OGMA, then I'm not comfortable with making a temporary appointment of somebody who got 400 votes versus somebody who got 4,000 votes. So we need to create the situation, and this idea of a temporary like a short-term sort of, that's not the way that it works in other tribes. Little Traverse is an example. They had Regina and Stella Kay, and they're both elected. And administrations are huge. There's a lot of responsibility. The chairperson of their tribe was in charge. The vice chair, in large part, serves at the pleasure of the chairperson, and is delegated certain whole areas of the tribe and responsibility. And we know the new chairperson of Little Traverse, Winnie, and her vice chair, they work as a team. And so I support that notion. I don't know how that got left out in the original draft. But again, if we're coming back to saying, well, we're not doing it because it's not in the original draft, we aren't giving full fidelity to the original draft anyway. And we have found something that we believe will not work. It's not going to work for the speaker to become the OGMA in an appointment. And where we were short a vote last time, I don't think we are now. This notion of muscling through, I don't think we're short a vote now. So I think we have to revisit that. I would rather leave the OGMA position vacant than to appoint somebody that's not elected by the people, or somebody that's elected by only 400 votes of the people. I'd rather leave this position vacant. And again, the evidence of what the people want, and I can only guess at this, is the 3 times that appointments were made, the people did not support those appointments. And as good as some of those people, I'm not saying all of them, as good as some of those people like Joe Eitram are, and how much people like Joe Eitram, the people did not appreciate an appointment without a vote. And he didn't get elected because of that 2 years later. So let's take the experience that we've had and learn from the experience and not set ourselves up for failure. Why would we purposely want to appoint somebody that the people don't select? Why would we do that? That doesn't make any sense to me as an elected official.
Tyler, then I'll speak.
Yeah, so I don't want to rehash everything we did the last meeting or even this meeting. I'm in full agreement that the legislature, if we're doing the separation, it needs to be a distinction of the legislature and the executive, and having a position that can meld between those two things. So for example, like what if the OGMA got sick? The speaker got appointed because OGMA absolutely couldn't do anything. And at the same time, they proposed legislation in the legislative branch, they then transition into an executive role and then approve their own legislation. It's a loophole that shouldn't be there. Because we're only talking about removal or somebody just disappearing. We're not talking about like Ogama needs to take vacation with his family, take time off. Ogama could get sick. Something could happen. He could win the lottery. Like we just need to have a clear distinction to prevent and protect against those abuses. And we don't need to keep going in circles about what those abuses are, what they have been, but we know that they're there and we know that they could happen. And the more we can solidify the separation, the stronger it'll be for all of us. And that's all.
Okay, so I'm going to say something and then we'll poll on this matter. So first off, I think that one of the things that's of value with this amendment is that it can create better operations for the tribe, can stop some of the infighting. But if you have that conflict of interest where the secession plan is that the speaker becomes Ogama in the event of death, resignation, recall, whatever, it's not going to be there. There's always going to be an incentive if there's fighting between one body and the other body that you can take that guy out and then your guy gets appointed. Not appointed, but he falls into that. That's why you don't see that on the state level. Imagine for a second if Governor Whitmer didn't have a lieutenant governor and next in line was the speaker, who's Matt Hall right now, who just voted to pull back $645 million of appropriations. Imagine the increased level of infighting that would take place in the state of Michigan. Imagine the level of infighting that would take place in this country if there wasn't a vice president and instead Mike Johnson could be president if you have an impeachment and a conviction on the Senate level. Like, it's a conflict. And sure, speaker is in the secession plan, but you have a number two for a reason. Resignations from my office aren't uncommon in the tribe. In the last 3 chairmen, of which I'm included, you had 2 resignations, where one of the people was appointed, was investigated for intimidating, harassing staff, right? So we talk about not wanting to have a person fill that seat who isn't elected because of what could happen to staff. You could have people be fired. Certain positions we've already identified won't have certain protections like the staff in the Ogama's office, and political games are played and we want to move away from that. I want to talk about the new Constitution as well. I've never referred to that as a golden document. So their recommendations came 18 years ago. There's 12 months in a year. We have 2 meetings per year. That means roughly we've had 432 meetings since then. So there's been over 400 meetings where there's been an opportunity for that document to be placed on an agenda and passed, and it hasn't because there's flaws in it. It was created by a well-intended group of people, but there's problems in it. Like, one of the things is it increases the size of the board, which would become the legislature. But if we're talking about, an unwillingness to create an additional position with a vice Ogama, that's something that we're not talking about either, because the size of the legislature would expand drastically with that if it was approved. So that's my opinion. I think that it will reduce the infighting between the branches of government. It will eliminate the conflict of interest with the speaker being selected by the legislative body and then sliding into that position. And if this tribe has shown one thing, it's not a single person who's been appointed to be chairman has ever won a chairman election. Not even close. Our people are adamantly opposed to that. It's the biggest position in this tribe, and there's an aversion to anyone sitting in this seat that isn't selected by the entire people, not just a collection of people in this unit, that unit, that unit. It's a collection of all of our people, and it's sacred. So with that, we'll do a poll. Signify your vote by saying Vice Ogama or Speaker in line for the secession plan. That makes it easy. So are there any questions about it so we don't have to re-poll? It's simple. Who's in line if there's a death, a recall, a resignation, anything along those lines, whether it's going to be the creation of additional position, Vice Ogama, or Speaker. And I also want to say I've spoken to 2 people that I know that were on that committee, and both of them are supportive of a Vice Ogama, and they can't understand why it wasn't included because they can remember it being discussed. So, and I think that they're both planning on being here tomorrow too and speaking. So with that, are there any questions what we're polling on? Okay, then we'll poll.
Isaac.
Vice.
Larry.
Speaker.
Tyler.
Vice.
Lana,
Speaker.
Bridget,
Speaker.
Aaron,
Vice.
Kimberly Hampton,
Vice.
Sean, I know he's there. Rob,
Vice.
Kimberly Lee,
Speaker.
Michael. Sean, are you still on? No.
Vice.
So that's 6-5.
Okay. 6-5, so Vice is the majority. So let's take a 10-minute recess, and then we'll move on to the next section then, Ryan, okay? All right, 10-minute recess. So we'll continue where we left off. Go ahead.
So I don't know how this is going to land because Sean is on, but he didn't weigh in. And if again, a majority says speaker and not Vice Ogima, can we put a provision in where the people can override the decision of the council? Because again, to me, it just smacks of privilege and tone deafness if a decision's made that's not what the people of the tribe want, what the voters want. And we currently have a right of referendum. This would be something that I think if they pass it by resolution, it would be subject to referendum. And I think the people would easily overturn a decision to make an appointment for somebody who got 400 votes versus somebody who gets 4,000 votes. And I just don't think we should be out of reach. I don't think the legislature should be out of reach of the people in making a decision that the people don't want.
You'd also have that special election, so like if you'd have the referendum option, but that's gonna be coinciding with also the special election that the commission should be under the Constitution working on. So you'd have that avenue too, where the people are gonna vote in that special election on who they want to be their Ogama.
So then it comes back to, is there something we can put in place to limit what sorts of decisions could be made by the speaker as acting chairperson? Because they could do a lot of damage. They could wholesale fire a whole bunch of people and then create a financial liability for the tribe. And not only the financial liability for the tribe, just a disruption of people's lives of coming in and just firing people. That's horrible. We mentioned it earlier, and I know people bristle at bringing up the past, but in '08, when I left office, 155 people lost their positions under the argument that we were financially strapped and we had to make the decision. But the board voted to suspend the appeals procedures and the termination appeal procedure. And I'll stop there because I also know a little bit more about who was put on the list, but it doesn't matter. If there was no appeal procedure, you didn't have any due process at all. 155 people lost their positions without any due process. And that affected people's lives. They lost their livelihood. Tribal members who committed to the tribe lost their jobs and they had no recourse at all. And I appreciate Mike saying in support of the notion of some kind of tribal labor law, because that's one of the next steps in reform that we need as a tribe. Because currently it's completely discretionary to the board of directors, or the appeals procedure, which can be suspended. And that in '08, when I left office, the appeal procedure was suspended, and it remained suspended until 2012 when I returned to office. And I brought a resolution to reinstate the appeal procedure, as deficient as it is right now. That's better than having no procedure at all.
All right, let's move on, Ryan.
All right, Article 10 is nominations and elections. This is I should have said this in the beginning, but just to remind everyone watching, the highlighted stuff on the screen is the new additions that are needed as we separate out. And then the non-highlighted is our language that's currently already in our Constitution. So Section 1, voting units, the 5 voting units of the tribe in existence at the time of the adoption of this amended Constitution shall continue under the current boundaries located with due regard to the historic location of each of the historical bands of the Sault Ste. Marie Chippewa Indians. At 4-year intervals, beginning 4 years from the year of adoption of this Constitution, the Tribal Council shall cause to make a census and voter registration of the citizenship within each unit and shall publish no less than 3 months in advance of the next general election the results thereof. That language is in our current Constitution. It's just substituting council for board of directors for that section.
Aaron?
So I think that in the draft, again, back to giving fidelity to what the committee wanted, The committee asked for something different than what we're doing. They wanted an at-large, they wanted a Unit 6, and they wanted to compel the western end to be reapportioned and divided into, like, I think just below Gwin, all the way across to the border of Wisconsin. And then south of that would be Unit 4, north of it would be Unit 5. If you look at our current, this is already in our Constitution, but we haven't followed it. We haven't followed the proportion of how many council members you should have, because if we did, we would have like 60. So we're not in compliance there. And the committee came up with their idea. But if you look at the existing units, it is 100% exercise in gerrymandering. And people are learning about what gerrymandering is right now, because at the federal level, the Texas case and then California and all of that. But the gerrymandering districts in the past were designed to keep long-term board members in their seats. Because I won't be specific on it, but if you look at some of the way the districts are drawn, they don't make any sense. They are designed to keep the former incumbents, none of the existing board members, keep them in place. So I guess I'm okay with continuing with the amendment as long as we keep the language. At some point, the legislature is going to have to create what that apportionment law would look like. And then ongoing, the districts can be modified based on apportionment. So I guess I'm fine with that if that's the case.
Well, right now, the legislative branch is set at 12. And so even if we did a census, because you're locked in at 12 right now in the current language, that's where the last poll standed. It was going to be, no, we never got a consensus on making it 13. We talked about it.
It was even, yeah.
Oh, right, but the current amendment, it would be, you lose the chair seat, and then it's 12, and it's worded as 12 in the current language of this draft. And so you do a census, you can maybe reapportion where those 12 seats go, but there's not the ability to increase without a constitutional amendment beyond 12. Yeah. If that makes sense. Okay. Section 2, first election. The first election under,
Bridget has a question or comment. Go ahead, Bridget.
Well, since we're talking about the lines and whatnot, I just noticed on one of the documents that came out when it was listing zip codes for units. And it lists the 49781 for St. Ignace, but there's people that live in St. Ignace that still aren't voting in Unit 3. So I think some attention at some point needs to be looked at onto those areas. They need to probably be based on another, what do you call it, a census to get that figured out and change it at some point when we get, get time for that.
yeah, there's a weird bubble, the commission calls it. There's a weird area in units 2 and 3 where people think they're in 2, but they're in 3, and vice versa. And it's something that has been an issue for a number of years now. So, first election. The first election under this Constitution of the 12 citizens. Yeah, my global change. Sorry, the 12 members of the tribal council, the tribal ogama, and the tribal judges shall be conducted consistent with this Constitution and all duly enacted election laws of the tribe. Subsection A, the current tribal ogama, tribal chair, and tribal council members shall continue in office until the expirations of their current terms. Thereafter, elections for all vacant tribal council member seats will be conducted consistent with this Constitution. Subsection B, the current tribal judges shall remain in office until the first election of judges, which shall take place during the next general election of the tribe. They don't have term limits right now, so then this kicks in as soon, if these get adopted, as soon as the next election after the adoption of these amendments, we would elect chief judge, chief justice, and associate judge of the trial court. Subsection B, A, in the first election for purposes of establishing staggered terms of the judicial offices, the chief judge of the trial court shall serve 6 years, and the associate judge of the trial court shall serve 4 years. If you recall, we set the term right now at 6 years for all judges, but the first election, to make sure we have staggered terms, that associate judge of the trial court will serve 4 years, so that we keep them staggered. But then thereafter, the 6-year terms would kick in. Any questions there? No. B, in the first election, the Chief Justice shall serve a term of 6 years. The appointed justices, the appointed associate justices, for purposes of establishing staggered terms of office, shall serve terms as follows. 1 justice of the Supreme Court shall serve a term of 6 years, and 1 justice of the Supreme Court shall serve a term of 4 years. Then thereafter, all terms will be 6 years. Any questions in that section? All right. Do you want me to go through this? So this section didn't change. Eligible voters, this is our current language. 18 years of age or older, you're eligible to vote. You got to vote within your unit of residence. If you're outside, you can choose your resident unit of choice to vote in. And then Section 5 changed, instead of board of directors enacting ordinances, tribal council enacts election ordinances. Otherwise, that's the same as our current constitution.
Aaron?
So, so the ability to choose, so the Constitution requires a census for both people inside and outside to register to vote. The board has determined that the people inside have never had to register, so they were just automatically registered. The people outside used to have to register to vote every 2 years, and that was horrible to put that standard on them, which violated the Constitution, because the people inside have never had to register to vote. The people outside had to register. So the board subsequently voted to, once you registered to vote, you were automatically registered going forward, but you were also locked in place. And to me, I thought that was a better compromise, but come to find out, people didn't like that, because the argument for locking people in place, again, and this was decided by the incumbents for their own benefit, was people were unit shopping and being able to run somebody for one unit, and then if they moved to a different unit, or that they could, they could get groups of people to switch what unit they're registered to vote in to try to to change the outcome of the election. So as this is written, this doesn't resolve that. So, because we currently lock people in place. Once they've registered, they're locked in place. If they live at large, they can't change that. And I think my interpretation is if we have a separation of powers, if we try to deny people from switching their unit, their the unit of registration, then they can file a lawsuit, and it's not in the Constitution, so they probably would win that lawsuit. So do we need to put some kind of language in now to do it? So I don't know, the answer is.
Yeah, I don't know what the answer is either. We didn't change anything in this section at the direction of, so for the reason this is not strictly needed in a separation, but you're right, Aaron, you probably, same with the census, you're probably going to see in a separation of powers, citizens asserting their right to sue when they think a law is contrary. And they might think that if I live in Detroit and I'm stuck in Unit 3 because I registered in 2023 to be in Unit 3, but now it's 2032 and I want to be Unit 1 and I can't change, that is contrary to the Constitution, and then the courts are going to decide whether it is or isn't.
Bridget, then Mike.
So I guess in my interpretation, the people on the inside didn't get it to have to register because we basically knew what their address was, or at least that they weren't gonna be able to pick a unit other than where they were living, as opposed to at large gets the opportunity to pick a unit. And I don't currently agree that we can, people should be voting if they haven't chose a unit, but that's for another discussion. Um, as far as going back when people were unit shopping, because we know that sometimes people organize packs to take over elections, so that probably was happening when people were choosing those units. But I do think if we do pass any sort of new constitution, that those people that are at large one last time get to choose their unit, for, that they're going to be locked in, knowing that they're going to be locked in at that point. They should be able to choose one time. That's it.
Mike?
Few things. One of those point of information would be is that previously people in the unit did have to actually register to vote. Automatic registration didn't come till later. I was on the committee when automatic registration in the units became a thing, and then I was also on the committee later when outside became automatic. I wasn't on that, but there was windows. We had windows where people had to register, and it was a difficult window because of the time frames that were in here. So opening it up to just being, once you were registered to vote, you were registered to vote, and you were locked in. That was the compromise, because it was very difficult to register people in that window. So, but that, what Bridget brought up, Director Sorensen brought it up about voters being automatically registered, this is where it's at. It says right in here, and it's the same language that's in our Constitution, that says voters residing outside of any unit shall register. And so I agree that someone could bring this to court and probably argue that and probably would win. Because our current thing makes it very difficult to have a referendum now, because that threshold for registered voters, even though they didn't register, they were automatically registered for the outside, threw the numbers up so high that it's virtually impossible to get a referendum now because of that. And so I think people would win based on this because it's current language. They just don't have the right to fight it in court right now. The voting block thing, though, does bring up an interesting point, because I don't disagree with Director Payment's thing. Somebody might win if they could choose a different unit. The reason why I understand it that it was put in, though, it was to prevent people not having more voting power than the people in a unit. And Unit 5 is a great example, because they only get to vote once every 4 years. And if you were to allow membership to jump into that unit, vote in that unit, then 2 years later, jump out, vote in a different unit, and then 2 years, jump back into that unit, they now have more voting power than the people in that unit. And to me, that's why that was placed in, that was permanent. Do we need to revisit it and say maybe it's not permanent? Maybe you're only locked in for 4 years? I would be okay with something to that provision. But they shouldn't have the ability to have more voting power than the people in that unit. And so that's why I believe it was put in there. So I don't know if this is the place to put it in, or if it's in the election code to put it in. But that language of voters shall, in any unit, shall register, I like that it's still in here, and that it will probably go to court to be decided. So I'm not sure if we need to visit it here, or if we let the separation of powers be and let it go to court. So, yield.
Okay, Tyler, then Aaron, then we're in recess for our lunch break.
Yeah, just talk about that. Like, if we're not willing to talk about redistricting, as a council or government, then we need to let the people decide. Specifically for Marquette County, those people are not heard. You get the city of Marquette, sure, and then the area in Munising where most of the residents lie, but then you have Ishpeming, Negaunee, Republic, Wynn, K.I. Sawyer, and Scandia, all in Unit 4. So why don't we just allow them to choose the unit that they're in and redistrict based on that? Because I can guarantee you they're not going to be like, oh yeah, I represent most with people out of Manistee who live 2 hours away from me. And even then, Michigami is in my unit. And I've talked about this before. You can't even get from Marquette to Michigami without driving through Ishpeming, Nagani, Ishpeming, and Republic. It is impossible unless you take a canoe along the shore of Lake Superior to get from Michigami to Marquette, and then subsequently Big Bay. So, I mean, that needs to be addressed somehow. And whether we do it now or with the people or whatever, like, it has to be addressed because, like Mike just said, the jumping back and forth every 2 years would cause voter discrepancies, but also it will dwindle even more the voice of those people in the surrounding Marquette County areas that have to essentially affiliate with Unit 4, but are now utilizing all Unit 5 services at this point, with the community center and health center being up and operational at this point.
Aaron?
So, not getting in an argument about what actually is the record, but we can go back and look at different versions of the election code. The Constitution, first of all, says the census shall be conducted and voter registration for people inside the unit. That's the way the Constitution reads. It's always read that. And then it also says that at-large people have the ability to register in the unit of their choice. The board in the past has determined and clarified through the election code that people inside were automatically registered. So I was elected in '96, in 2000, and at no point, so this would be before, I think, your service on the election committee, Mike, at no point did the people in those two elections ever have to register if they lived inside the unit. And then in 2002 is when the board voted to lock you in place to get rid of reservation shopping. That was enacted in 2002. And then it locked people in place. And I thought people were going to be kind of happy with it because then they didn't have to register every 2 years. Because before that, before 2002, our at-large members the burden was put on them to have to register every 2 years. And that was by design to create support for people who live in the service area to keep getting reelected by the people that are at home. It was a disadvantage to the people who lived at large because they had to register to vote, even though the Constitution said both populations have to register to vote every election. No, the people inside every 4 years. The census shall be conducted every 4 years and a voter registration. And they just interpreted that they were automatically. There was a time when the board voted to require the people inside that turned 18 had to register to vote. So for, I think, one election cycle, they had to send in their voter registration. But then, I think 2 years later, the board voted to eliminate that and make the people inside automatically registered to vote again. So rather than do a back and forth on this, if we could get a legislative history about what the law actually required. But either way, and I do appreciate Mike bringing this part up because I never thought of it, is we will have people who will try to file a lawsuit to say that the at-large people can no longer be automatically registered to vote. That's an interpretation that was done in a code, not in the Constitution. The Constitution says both populations have to register to vote. The inside every 4 years, the outside every election. And so if we don't fix it here, then you could argue the legislature can draft up the law, but if the law is not consistent with the Constitution, it is going to end up in a lawsuit. So we probably should just fix it now. And I guess the other thing, and I'm glad that Tyler brought this up, is, again, people can see what's happening at this table. Sometimes we will say we want to keep, this purity and pristine of what the draft Constitution in 08 said, and then sometimes they will completely do something different. The fact that we're doing individual amendments and that we couldn't get a majority of this board to even consider meeting over this until we agreed to just do individual amendments means that we're not consistent with the fidelity of the draft document. And so one of the recommendations of the committee was that because of gerrymandering, I remember they had this conversation, units 4 and 5 are all screwed up in terms of where people are registered to vote. And the solution from the committee's perspective was to redistrict units 4 and unit 5. The committee recommendation was to drive a line just below Gwynn no, I think it was just above, no, below Gwynn, because currently Gwynn is in unit 4. To draw a line just below Gwynn, that's KI, across to the western side of the state, and then unit 4 be south of it and unit 5 be north of it. That is the committee's recommendation. So when you hear people at this table say, we want to go with what the committee said, we're not even considering that. And I think it is, one other thing is, you also have the at-large districts and all the arguments and all the controversy around at-large and Unit 6. But this issue's different than that issue, because we know that there's an apportionment problem. We know that there is a gerrymandering problem with Units 4 and Unit 5, and the solution the committee came up with was to redistrict based on drawing that line across the UP. So I don't know why we're not even considering that right now, that we've abandoned that notion. But, you know, every time somebody says we want to do what the committee said, we should go back and revisit that issue, because it would solve that issue once and for all, so.
All right, guys, so that concludes the speaker list on this issue. We're going to go ahead and take our lunch break, so we'll reconvene at 1 o'clock and pick up where we left off. Okay, so 1 o'clock, please be back. concluded, so let's pick up where we left off.
We were discussing the section here, sorry, it's really loud. With the eligible voters, voting units, and election ordinances. We have not changed this section from our current constitution. It's not strictly necessary to change it to get the amendment for the separation. That's why we've left it alone for now. But before our break, we were discussing whether we want to try to figure out some language that maybe would limit some of the potential lawsuits, namely outside unit voters who are currently automatically registered and have to pick a unit. There may be challenges once we separate in the courts on whether that is constitutional or not. Probably, if push came to shove, my recommendation would be right now to focus on the amendments to get the separation. And I suspect this is supposed to be a living, breathing document. If we get the separation, we'll probably have other constitutional amendments that we want to push later. But the legal department doesn't have any strong feelings either way. So we can leave this for now and move on, or we can pick up the discussion on whether there's suggested changes from the board.
I don't see any hands up, so I'm assuming that everyone's okay with the language.
All right. Article 11, sovereign immunity. Section 1, sovereign immunity. The tribe shall possess sovereign immunity. Nothing in this Constitution shall be deemed to constitute a waiver of sovereign immunity from suit, unless specifically stated herein, except that tribal council may authorize a waiver of sovereign immunity by law. Any authorization by tribal council to waive sovereign immunity shall be specific and for a limited scope and duration. Typo here. Section 2, suit against elected officials and employees. The tribe, its elected officials, its executive officials, and its employees acting in their official capacity or within the scope of their authority shall be immune from suit except to the extent waived in accordance with law, provided that any citizen of the tribe may bring a suit exclusively in the judicial branch to enforce the terms of this Constitution. In Section 3, suits against judges and justices shall be immune from suit in law and equity for actions taken in their official capacity. Section 1 is our broad reinforcement that we actually have language above as well, and in the legislative branch, just reiterating our sovereign immunity as a government. And sections 2 and 3 are meant to limit suits against the tribal officials and judges when they're acting in their official capacity. If they're acting outside that scope, then they're acting contrary to the Constitution, and then citizens of the tribe could bring suit saying this was not within their scope. But it's meant to limit frivolous lawsuits against officials.
Good, Mike.
Going back to the sovereign immunity section, do we need to be specific in here at all regarding, or is this something that will flesh itself out, that the executive branch or any of the authorities can't waive sovereign immunity unless expressly, because that right lies with the tribe itself, so it just says tribe, so does the legislative branch, or is that the only branch that can waive immunity? And should we be stating that, like, gaming authority can't waive it unless authorized by the board? Enterprise, Sault Ste. Inc., stuff like that. Like right now, we have it in so many different places, but if we're doing a constitutional thing and we're actually saying sovereign immunity in here, do we need to put that language in there that says that they can't do it unless authorized?
I don't think you strictly need it because you have that only tribal council may authorize a waiver of sovereign immunity by law. And when we currently have those laws, and if we reinforce them in a separated government, when the tribal council allows a limited waiver by the authority, they're authorized in that by law. So you have it covered in that section. there's no harm in if you wanted to make it more explicit, but I don't think it's necessary. I think you got it covered because tribal council creates all the laws. Authorities can only waive their immunity as allowed by the law that the tribal council enacted.
Yeah, I'm good with that. I just want to make sure we're all on the same page.
Yep. All right. Sorry, my articles got messed up with their numbering. Article 12, right of referendum. This has not changed. This is our current language in our Constitution, which allows a referendum with at least 100 eligible voters to sign the petition. And then it goes to what would be the tribal council, I suppose, not the board.
So what's everyone's thoughts on 100? I can get 100 signatures in about 2 days, and I'm not exaggerating. So do you guys want to be able to stall government with 100 signatures? I mean, you obviously have to have it a certain level that's attainable, but you shouldn't have nuisance referendums taking place when we know how much those elections cost to run.
And just for information's sake, Austin, the 2008 draft had 5% of the eligible voters to do a petition, whatever that would equal, 5% of 40,000. But that's what
Yeah,
the 2008 one
my
did.
opinion has always been that it should be a certain proportion of the registered voters. If we don't want to use registered voters, we could have the people that participate in elections and cast ballots, because it should be a percentage, because once upon a time when 100 was selected, we had a fraction of the tribal membership that we have right now. And I mean, we all have to get about 100 signatures, well, chairman does to run for office, and it takes a couple days. You know, it's just my thoughts, but it has to be attainable by people because they should have a right to referendum. Isaac?
Yeah, I think the percentage of the voters that voted in the last election would be the best way, because it's going to change from time to time, right? And it's automatically going to change, right? The board doesn't have to decide that, or we need a constitution amendment to decide it.
Okay, Rob, then Aaron?
Yeah, I agree. It's got to be attainable by the members, especially if they see legitimate reasons to recall. But as we know, not all of our members participate in elections, which is their right to choose to do so or not to do so. So I would base it on the amount of voters that participated in the previous election. And looking at the numbers, I think that 10% of that number would be reasonable, whereas, 5,000 to 6,000 votes are cast in a chairman's election. If the chairman did something worthy of removal, I think that 400 or 500 signatures would be attainable pretty easily, but also not so easily that we're going to be dealing with frivolous removals at all times. I think that this needs to be protected, and it needs to be something that members feel confident that they can enforce if they need to. So I'm open to 10% of the votes cast in the previous election, and also have that be per unit too. So, for instance, in Unit 1, I think there was something like maybe 6,000, or actually it was less than that. So you're looking at less than 500 signatures for a removal, which I think is reasonable. I could put out a post, like the chairman said, I could put out a post right now, and by Monday next week, I will have the signatures if I need 100. It's not fair to operate in that situation either.
So we may be talking about two different things. So we're not on recall right now. We're talking about a right of referendum. So this would allow the tribal citizens to overturn a vote of the tribal council. So that's what we're talking about right now. Aaron, then Mike.
I think 10% for all of it. So that's
Yeah.
my suggestion.
I think that would be reasonable. I would do chairman election, 10% that participated in the chairman election, and then it would come back and the council would vote on it. So Aaron, then Mike.
Yeah, so the numbers that you were sharing just now, Robert, aren't, well, the chairman election, the winner gets about 3,800 to 4,000 votes. but the number of votes that are cast are like about 70% more, or no, 70%, or 0.13 more. So, about 7,500 votes are cast in the chairman's election. And if we use 5% of that, that would be 350 signatures for the referendum, which is good. Or 10% would be 700. That might be kind of bordering on too cumbersome to get people to do that. But I think the right of referendum can be different than the right of recall or removal. I think the threshold for removal should be significant. It should be 10%. And the reason for that is because the people elect the chairperson or the council. And so to undo that, it needs to be significant. Changing a decision of the board is important, but not as significant as undoing an election. So I don't know, maybe if we did 5% for referenda of the votes cast in the previous chair election, and then we use 10% of the votes cast in the chairperson election. The standard right now, I think, is removal is 10% of the votes cast in that particular election. Is that correct?
Yeah, it's 10%. Right now, it's 10% of the eligible voters. So for like a
For referendum.
for a referendum.
No, that's what no, the removal is
Yeah, for
10%.
removal right now is set at 10% of
The votes cast. in
the
previous-
registered voters eligible to vote. We can change it to votes cast, but right now, it's 10% of whoever's eligible to vote in Unit
No,
1, for
no,
instance.
for removal?
Oh, you mean for our current code? I'm sorry. I thought you meant the draft.
Oh, okay, all right. The current code for removal is 10% of the votes cast in the previous chair election. Because I know when that censure removal was circulating on me, I know they couldn't get 100 signatures, because I know that the petitioner came and had a special closed workshop with the board to ask the board if they would lower the number of signatures, because they couldn't even get 100. But you needed something like 700 votes or signatures for removal then. But what I'm saying is I think the threshold for removal should be higher than the threshold to undo a decision of the council. So I think it should be 10% for removal, and I think it should be 5% for referenda of the total votes cast in the previous election, the previous chair election. Because if we just say the previous election and it's an off-chair election, Manistee, Unit 4 is usually kind of like the highest number, total votes cast. Sometimes it goes back and forth between Unit 4 and Unit 3. And 10% of that would only be like 120 or 130 or whatever. So it should be tied to the total votes in the chair election.
Yeah, in our current removal code, you're right, it says the equal to or greater of 100 signatures or 10% of the votes cast in whatever unit in that last election.
Yeah, and that was put in place to insulate the really small units, because previously it was 100 signatures, and like for Unit 2, they only get 400 votes, 450 votes, and 10% of that would be 40 signatures to compel somebody to be removed. So that was 100 or the greater of 100 or the votes cast. So that was done to insulate Unit 2 and Unit 5.
Actually, Director Paymont had touched base on what I was going to. I think it should have different things too, 5 and 10%.
Okay. So Ryan, could you remind everyone how many votes were cast in the last chairman elections? That way we can keep these percentages in perspective and figure out roughly what would be needed in a referendum and a recall.
Yeah, I'll find the exact number, but it was just a little above 7,000 total votes cast in the last general election.
So you need about 350 signatures for a referendum and about 700 to do a recall. Okay.
With those percentages.
So I think both numbers are reasonable. I think that they significantly lower the threshold, which is a good thing, because right now the numbers are pretty high for what you need to get as far as signatures go. So is anyone opposed to 5 and 10%? 5% for referendum, 10% to do a recall, and that would be in reference to the referendum and the recall. Okay, Rob, you have your hand up. Tyler, you have your hand up. I'm not sure if you guys disagree or if you guys want to speak about something different. Rob, go ahead.
I forgot to put my hand down, Austin. I don't have anything to add.
Okay, go ahead, Tyler.
Are we keeping for the recall or 100, whichever is greater? Because I would still put unit 5 and 2 at like 50 to 70, depending on how many people vote in that election.
Ryan, what are your thoughts? We wouldn't want people to get removed by 50 or 70 signatures. That's silly.
Yeah, so last election, like Unit 5, 398 ballots were cast. So that'd be 39. So I'm not opposed to having like 100.
No, that's not. There was 400. There was 550.
Oh, I'm looking
Somewhere around there.
I'm looking at the end of cycle report. Well, so there's 400 to 500, which is still less than 100. If we take 10% of that, so. I'm looking at the 2024, I'm looking at the primary, I'm sorry. And that was just, yeah, that was, they were voting for the chair. There was 400 and, so this is not the last general election for Unit 5, but the last election that we had in 2024, 414 votes were cast for the chairman race out of Unit 5.
Which is about 200 less, no, you'll know this best, Tyler, but that's about 200, 250 votes less than total cast in a Unit 5 election.
Yep.
Yeah, so having the 100 as a minimum or 10% whatever is greater, and I'm not opposed to that, that's fine.
What are you guys' thoughts? Is everyone okay with that? Aaron?
Well, my thought is, I think that this is unique to Unit 5, because there's only one election there. And I think it should be proportionate to the votes that are cast in a Unit 5 election. Going based on an off election year, 250 votes less is something like 40% of the total votes cast. So it should relate to the number of votes that put somebody in office. And this would be unique to Munising, or to Unit 5.
So what are we proposing doing in that situation?
So I think for the unit reps, it should be a percentage, and I think it should be 10% of the votes cast in the previous unit election, or for chair, 10% of the votes cast in the chair election. For
What are we saying
referenda,
for chair?
Right.
That's for unit reps.
right, so.
Okay.
So 10% of the votes cast in the previous unit election should be the threshold. And for the chair, 10% of the votes cast in the previous chair election. But then for referenda, it should be 10%, because everybody gets to vote on that.
Could I repeat what you're saying? That way I know I'm understanding it.
Yep.
So what you're proposing is if you're going to recall the chairman, at least 10% of people who participated in that last chairman election have to sign in support of recalling that chairman.
Correct.
Okay.
10%.
For a board member, legislature, you have to have 10% of people that participated in that board member's election. Okay.
Yeah.
Is
Yeah,
that,
and the reason for that is because otherwise you're setting.
Or
the-
100, whichever is greater. I'll tell you, not that it's ever going to happen, but I'll tell you this: there is a family with more than 70 registered voters in this unit.
Yeah, I think for Unit 5, that would do it, the 100.
Tyler makes a good point. I mean, if you look at his unit, I mean, you got people in Nagani, Ishmael, people that are really Unit 5 members,
Yep.
you know, confined to a Unit 4 election.
Yep.
And that's just a fact. That's why there's so few people that participate in that election.
And if you don't have a separate treatment for Unit 5, so this is a matter of equality versus equity. If you have an equal treatment, it is inequitable, because Unit 5 on off-chairman elections, you just share the numbers, is about 250 votes less off chairman elections. And the threshold for removing a Unit 5 board member should be the same, 10% of the votes cast in that unit's election, for unit rep, not an off chairman election. And this is unique to Unit 5 because they only have one election every 4 years.
Okay, so it would be, are we saying 10% or 100, whichever is greater?
I'm good with 10% or 100 because 10% right now is probably about 75 signatures. 100 is 25 more, so.
Yeah, because you're looking at the 2024, so that's like a different unit. Like Unit 2 had a race. The general election saw 679 ballots returned. Unit 3 had 1,195. Unit 1 had 2,500. Unit 4 had 765. So having that 100 as a minimum or 10%, whichever is greater, makes the most sense.
What number was the 2024 again?
Unit 5, 2024 was, the general election was 414 ballots received.
So that's 265, we were pretty close. So going with the higher threshold or a percentage of the votes that are cast in that unit makes sense.
All right, Lana.
Yeah, yeah, I know we're throwing around numbers here, but I can remember in Unit 2 when we had half the voters vote in a chairman's election. I think I got over almost 700 and my opponent got a little over 400. So there was elections where it was more than 700, more than 400. It was over half that we had. So I just wanted to throw that out there because it's the numbers are not completely accurate. So that's it.
So is anyone in disagreement that we should change this for a recall, or, I'm sorry, for a referendum, 5% of the total votes cast in the last chairperson election? We'll start with that. If we need to poll, we can poll. It makes it much more reasonable. Okay, so I'm not seeing any objections there. Are there any objections for his recalls, 10% of the votes cast in that last elected representative's election, or 100, whichever is higher, that applies for chairman and individual board members who will become legislators? Is there any objection there?
And just for point of information, how many would that be? It kind of cut out.
It changes how many people vote in each election.
Okay.
So it would be 10% of, like for instance, let's say a recall petition is filed on me, it would be based on 10% of the votes that were cast in my election, at least 10% of
700.
people. Yep.
Would be
And-
700
Yep,
for the
and if-
2024
If
election.
someone were to file one against you, it would be based on how many people participate in the Unit 2 election. So it'll be individualized.
Thank you.
Okay, any disagreements here? Okay, so let's punch that in, Ryan.
All right, so it'll be affirmative vote of majority of at least, we said 5%. Of the amount of votes cast in the previous tribal Ogama general election. Of the 5% of the total votes cast. Bearing the signatures of at least 5% of the total votes cast in the previous tribal Ogama general election. And we'll strike out 100.
So I want to make put a pin in this because when the board voted to automatically register everybody in the chair's elections, I watched all of that and I think it was the right choice to make. But immediately people started saying it was done in order to contravene and frustrate the right of referendum. But you don't see any opposition right now to readjusting that threshold to fix that. And the elders did advise that. If you remember when they came to us, they said, can you guys fix this too? And that's what we're doing right now. So, you know, for all of the naysayers out there that are claiming it was created to contravene and frustrate the right of referendum, that's not the case. You're not seeing that right now because there seems to be unanimity on lowering the threshold from 10% of 39,000 down to 10% of the votes that were cast in the previous election.
So I apologize, you guys. I'm a little confused. So was that, you were trying to do 5% to get a petition or 5% to overturn?
So it would be
Overturn.
5% for referendums, 10% for recalls.
5% for a successful referendum?
Yes.
Got it, okay.
So 5% of the total votes cast in the chairman election, and as far as recalls go, it would be 10% cast in that elected representative's election, or 100, whichever is greater.
How many, so there's two things with the referendum, right, though? There's how many signatures you need to start a referendum, and then there's how many votes need to come in to have a successful referendum. And I apologize, but it sounded like we were talking about having a slightly higher threshold of 100 to get a referendum started.
Yes, the
But
5%,
then-
we just polled on that,
Right, but that's what we pulled on, but then we still need to talk about
yeah.
the 30, right now it's 30% of the entire eligible membership to return to get that referendum to be a successful referendum election.
We still have to talk about that.
Okay,
So
I just
let's
want to
discuss
make
it
sure
right
that I
now.
was on the same page.
Yep.
Okay.
So, what do you think is reasonable? I think that the percentage that turned in their ballots for the constitutional survey is reasonable. You're never gonna have 30% of people return their ballots. You just won't. I mean, people that do statistics for a living will tell you that. Especially when it's unsolicited ballots being sent to them. Like, these aren't people who signed up for this specific election. They're just registered, so they're gonna receive one in the mail. And the likelihood that greater than 1 in 3 are gonna return them just isn't reasonable. So I'm willing to compromise on it. What do you guys think? Aaron?
So the number of people who polled is consistent with the number of people who vote in the chairman elections. So I know there's this big argument that, only a minuscule number of people participated, but again, many less people vote for board members, and we count that as valid. So it's a matter of, do we keep the percentage of the total registered voters, or do we change it to those who participate? And I do think it's fair for us to go based on a percentage of those who participate. So the same threshold, I believe, we have to have 30% of the people, but if it's 30% of those who regularly participate in chairman elections, that's an achievable number. Now, having said that, I do think and I know I'll get blasted for this, but I do think we're better off not having every decision overturned with a very small threshold. So I do think having a significant threshold is important, but not an impossible threshold. I do think it's impossible right now. The 30% of the people registered to vote when people were automatically registered, that's not something that's ever gonna happen. And the elders recognize that, and that's why they recommended that we fix that.
Okay, well, let's break that down really quick before I call on Bridget. So, what you're proposing is 30% of the people who participate in the chairman election to make it so this passes. So, Ryan, again, how many people participated in the last chairman election? Was it 7,000, 7,500? 7,800?
7,300.
7,300?
1 second, yeah. 2024.
So 30% of that would be 2,190.
$7,375.
Okay.
Sorry.
And how many people participated in the constitutional amendment survey out of all the people that were registered?
It was like a 16% return.
Which would have
It was
made
roughly 6,200.
6,200? Okay. All right.
So
that
what
kinda-
about a 20% return? Because if the chairman took 18%, or even 18%, if that's what we're talking about,
Hold on 1 second, guys. I got some speakers up already. So if you could answer Tyler's question. So Tyler, are you talking about 20% of the total registered people, or 20% of the people that participated in the chairman election?
20%. Well, if you're saying that what, 7,300 were returned, that's roughly 18%. So if you wanted to be reasonable, what if we just say 18% of total registered voters? Because that generally reflects how many people would vote in a chairman's election. And then we can make it a reasonable rate of return for this purpose. Instead of going off of a percentage of people that vote in the last election, go off a percentage of the total eligible voters based on the last election or something. I'm not sure.
Okay,
But that reduces it, the threshold 12%, which would make all of those last elections that we went through valid. It would have made all of them valid.
so rephrase that so I can poll people when it comes to it, because I'm gonna write down everyone's suggestions, and if we need to poll, I got all the
I would just say
options.
the total amount would have to have percentage return equal to that of the last chairman's election. So if we had 20% of return ballots in the last chairman's election, that would be the threshold for a referendum.
So for example, if 15% of registered voters participated in the last chairman election, you'd have to have 15% or more returned referendum ballots for it to be valid, correct?
Correct.
Okay,
Correct.
so let me finish writing that down and I'll get to the speakers list.
I think it was just an example.
Okay, so I got Aaron's suggestion of 30% of the people that participate in the chairman's election. I got Tyler's suggestion of it has to be the same percentage or higher, the people that participate in the chairman election compared to the total registered voters. I'm gonna get to the speakers list, and then we'll narrow down these options. If we need to poll, we'll poll. So Lana, then Bridget.
No, Bridget was first.
Okay, Bridget, then Lana.
Okay, so all these changes that we've been going through, and tomorrow night there's a couple items to vote on. So if we make it through this today, and it could get voted either way or either version, at what point do the members get to have their say in these changes that we've made? Because even if we put out a whole document, that doesn't mean there's been so many changes to it. It doesn't mean that was the intent in the first place, which I'm not saying that we didn't need to make changes, but we've had several workshops and we've never allowed members to have their say in, yeah, they might say we support three branch or whatever, but they're not saying, hey, we support 5% or 10% or any, a vice chair or not. So is there going to be a time that members get to have their say in this?
So I guess the response to that would be they'd have their say if this passes and that they get a secretary election ballot, they can vote yes on it or no. And if it doesn't passes, we can go back to the drawing board. There's also a section for public comment during the meeting. And I mean, we all have cell phones, we all have emails, we're all available to the membership. I mean, these are open to the public. We have one person sitting here right now. Whatever you guys think as far as membership participation, but it'd be difficult to poll every single member for every proposed change on this. I mean, if you can come up with a reasonable solution, I'd be willing to hear it out, but I most certainly wouldn't want to delay the vote on this any further.
I'm not saying poll every single member, but I'm just saying when it comes to an actual final document going out, there could be people that are voting no for one little word that might be a different word for 10,000 members, but it could be something that simple that instead of people just having, and I mean, it wasn't advertised that people could today log in and give their input either. I'm just asking that question.
I mean, that's the best answer I have, They'll have their say when they get a ballot from the BIA for the constitutional amendment, and we all should be available. We all should be taking what they say to heart when we vote on these polls. I mean, we have a representative government. We don't have a total democracy. I can't think of anything better, really. Lana?
So just just for the benefit of the people that, because there's people online. So right now, Ryan, a right of referendum is how many signatures?
100 signatures to start a referendum petition, and then when the election happens, you need a 30% return rate for it to count, and then majority rules, as long as there's
Okay.
30% back.
Okay, so right now it's 100. What did the original, because, we've changed so many things throughout this process that it's kind of hard to keep up. And then all these numbers being thrown out that sometimes aren't accurate. What did the committee originally say for a right of referendum?
5% of the eligible voters, so 5% of the registered voters to get a petition started. And
And
then,
that is in the 2008.
and that was 2008 draft. And
Okay,
then
and that's what we
just,
had.
yeah, once they had the election, whatever the majority rules, there was no return threshold. It was just 5% to start a referendum. You do the election, whatever the majority says, that's what prevails.
Okay, the 5% to start, I just gotta be clear on this when we do poll. So right now, the right of referendum is 100. I don't think we have referendum madness, so I would probably keep it at 100 if it was my choice, but the committee said.
Could I jump in? It's not
5%?
It's not 100, it's 5% of the registered voters. So it's not
Right now,
100.
it's 100.
Right, but we're talking about the new constitution, right?
I know we're talking about the new, I wanted to know, my point is, right now, we don't have a bunch of referendums, so I don't think that's a problem. I think if 100 members feel strongly, that's my opinion.
Ryan, could you clear this up? So with this document, if we don't change it, how many signatures do you have to start a referendum?
So if we don't change,
5%.
Right, which is more than 100.
if we don't change anything in our current constitution, you need 100 signatures to start.
Correct.
So that's what's in the new constitution proposed 2008.
No, 2008 was, if we do
That's-
2008, it's 5%. which
That's
is
what we're
we pulled
talking
on.
about.
Yeah.
I mean, if we're gonna stick with this document, what does this document say, rather than, okay, we like the document except for this part? So what is 5%
Can I
of
just get
the?
my point across, Austin? Because me and him were on the same page. I was getting my questions answered.
I don't
wanted
think you
to-
guys are on the same page. What he's saying is, what we currently have is 100, but if we
Yes.
implement the new constitution, it's far more than 100. It's
Yes, I know
5%
that.
of the registered voters, and there's so many registered voters, 5% is way more than 100. It's probably a couple thousand.
I know that. I'm on the same page with him.
Yeah, it's like 2,000 almost probably. If we do 5%, if we take the 2008 language, which is 5% of everyone who can vote, we have over 39,000 registered voters, so you're at 1,900 and change if it's 5% of that. If we just implement 2008 as worded, is that what we're asking?
So if you vote what the Constitutional Committee wanted in their 2008 draft to start a referendum, it's not 100 signatures. Based on the current number of registered voters that we have, it's 2,000.
I know that. My question was two separate questions. I wanted to know what the original was, because my point is, we don't have referendum madness now. I know it's not gonna stay the same to 100. I wanted that to be pointed out to what it is now, and I know now that Ryan answered the question, the original intent of the committee was 5%. I know that 5% is more than 100 signatures. I'm done.
Ryan, how many signatures do you need to have to start a referendum right now?
Currently, we need, in our current constitution and laws, 100 signatures starts a referendum.
Okay. Okay, Aaron.
So it's really frustrating because sometimes we want to do what the committee says and sometimes we just throw it out like it wasn't even important. The committee recommended 5% to increase the threshold of number of signatures because 100 signatures is tiny. The 100 signatures was established when our membership was about 2,700 people. And so 100 signatures divided by 2,700 is how much? Who's really good with math? Okay. Divided by 2,700. So the threshold was almost 40%. So I don't think it's tenable for us to ignore history and say, let's go back to 100. The committee is saying 5%, but the committee is saying 5% on the number of people who were registered to vote in the last election. before the board voted to automatically register and add another 25,000 people automatically registered. So we have to believe the committee's intent was 5% of the people who are participating in our elections. So 5% of 7,800 is about 375. That's not an impossible number to go out and get signatures. It's not easy. I've gotten thousands of signatures on referendums and submitted them to the point where the election committee changed the rule where they only had to read the first 100 and then they disregarded the other 1,000. I did 1,100 once on a referendum. But if we stick with 5% of the total automatic register, that's about 2,000. So I think the good compromise, because people are saying they're casting aspersion on the board, thinking that the board changed the referendum, changed the automatic voter registration in order to get around the right of referendum. And I don't think that's true. And as far as we're not in referendum madness, 2 years ago, we were. We had how many referendums submitted within 1 year? 3 or 4?
Lots, and the reason it changed is because I think that they realized, and it was inadvertent, because there's no downside to registering people to vote. I mean, it's the first time I've ever heard of a voter registration drive being a bad thing. The total number of referendum ballots that needed to be returned to validate a referendum increased because you registered more people to vote. So it wasn't because it was just 100 signatures. When it was 100 signatures, you had tons of people do it, and that's still what it is. It's just the threshold to get those ballots returned, to validate it, is a lot higher right now. But just to give a timeout, we've already talked about how many signatures have to be signed to start a referendum. And we've already polled, and no one objected, the 5% cast in the last chairman election, which would be about 350, which is more in line with the size of our tribe now and things like that. So what we're talking about now is the total percentage that have to be returned to validate it. That's, like, we've moved on.
Yes, that's correct. We did poll, there was no objection, so now what we should be talking about as a point of order is the percentage that it would take to enact a referendum, to either support or overturn it. And I support a high threshold of 30%. And the reason for that is because government shouldn't be flip-flopping around, and people get their nose out of joint. If you look at it, some of the, I better be careful how I say this, some of the referenda that we were in referendum madness 3 years ago, because there was about 3 or 4 in a row, and they were to overturn simple decisions that the board made, and we ended up spending, $20,000 or more for each
Minimum.
referenda, and we didn't make the threshold. So that is referendum madness. So the number of signatures should be significant. We already polled on that. There was an objection. There might be one objection now, so let's move past it. Note it in the record, but let's move past it. And now we're talking about what is the threshold in order to enact a referendum. And I think 30% of those who participate in the last election, in the
Chairman
chair's
election.
election, should be the number.
Okay. I have Lana, Mike, Rob.
Yeah, it might be nice to just try to dismiss my questions or interpret them the way you want to, or keep interrupting when I'm talking. It's not nice. It's not kind. I had questions. I wanted to know what we are in right now for the benefit of the members. That's 100 signatures, and what the committee wanted for theirs. So when it comes time to poll, I can poll. For my questions to be interpreted, you just jump on and interpret what what my position is. I think I'll just refrain and listen and let the show go on, I guess, because I can't speak.
I'll make a point of order.
I can't speak. I'm sorry. This is exactly what I'm talking
I'm
about.
calling for a
Austin.
point of order which takes precedence. The chairman has already said that we polled on that issue, that you didn't weigh in when we polled on it I'm not sure why you didn't, but you didn't. Now you want to revisit it, but we've moved past that. So let's move on, please.
Mike, then Rob.
I'm going to yield. It got changed. We were talking about the votes cast, and it hadn't been changed till just now on the screen now. So that is what yeah. I'm okay with it being votes cast in the previous Oklahoma's general election. I think the other threshold was impossible, and that is why we haven't seen referendums, is because we have made it impossible. And we could still address that, right? Nothing prohibits us from changing the referendum code right now to not being such a high percentage of registered, well, even non-registered voters, really. We automatically registered so many people that we made it impossible for referendums. So that is also something we probably could revisit when this is all said and done too, is we don't have to wait for the results of this to address that. So it got changed on here. I'm good with what's been written right now, so I'll yield.
I think most people recognize that 100 signatures to start it was too few, but the percentage that need to be returned to validate it is too high. So, I mean, regardless what happens, Mike makes an excellent point. I mean, we've had these discussions at this point, and there's ways that we can improve code because the members do have that right. Rob?
So I have a little bit of a different view on this. So where I may differ from people is I do believe that we need a much higher threshold to initiate a referendum, because 100 I feel is just too low. But once it is initiated, and I think if you have 200 to 300 signatures required, I think if the board or legislative body does something that upsets the membership enough, 200 or 300 signatures is not unattainable, but it sets a high enough threshold to give merit to the discontent of the membership. Now, once it gets to that point, and members successfully garnish the signatures needed for a referendum, I don't believe there should be a threshold of number of signatures that of votes that come back. At that point, I think majority rules, and it's up to us as leaders to voice why we believe what we believe and why we believe that our vote is in the best interest of the tribe. But at the point that members garnish the correct signatures to get that on, I think whoever votes should have a voice, and that voice should matter. I don't think we need a threshold to overturn it. And if you look at when we're talking about that time period where we were in a referendum frenzy, even though those didn't meet the 10% threshold, had we just went with majority rule, all of the laws that the board presented at the time would have been upheld simply by majority rule. So I think there should be a higher threshold to initiate a referendum, but no threshold after that. I support majority rules. Whoever votes in that election, what they determine is the law. That's what I believe.
Okay, Rob, so this is what I'm writing down as your option. So again, we already polled to determine how many votes need to be cast to initiate a referendum, and that's 5% of the votes cast in the last chairman election. So that would be about 350 if those votes remain about the same, but it fluctuates. And I'm going to list your option as there's no minimum required percentage that need to be returned to validate that referendum. Okay?
Yep, and I agree with the higher threshold of votes, so we have already moved past
Yep, we've already
that.
done it. We moved past
Yep.
it. Okay, Aaron,
Okay.
then Lana.
So the thing why that doesn't work for me is, all right, let's say it's, I don't know, like whatever percentage, 5% of the votes cast in the previous chair election to initiate a referendum. And then let's say it's a referendum on something that's just so frivolous that people are like, what the hell? Why are we voting on that? People aren't going to participate, and we do have that. You see a low turnout on people on referendum because the people have other things happening in their lives. They don't want to be overturning every little decision. So let's say people find it frivolous and only 100 people vote. And if it's 51 or just over 50%, 51 people could make that decision. So there needs to be a minimum threshold. Without a minimum threshold, let's say two people vote. No, you have to have three. 3 people vote and 2 people vote to say we reaffirm it, or only one person says we vote to reaffirm it. So are we really good with having just 3 people make that decision, or 100 people make that decision? I think that's why there's a minimum threshold. So whatever that threshold is, 30% to me seems to be kind of small to make a decision. Well, that's 30% of the people who participate. So the number, making 30% making that decision is already small, but if we say there's no minimum, it could be 100 people. And I don't think we're really wanting that.
Okay, Lana?
Nope, I yield.
Any further discussion, guys? So give me 1 second. I'm just writing down these polling options and we'll discuss them one last time and see if people still want to have their proposals as options.
Do you guys want to know what the 2008 language was?
Sure.
Okay. So 2008, it was 5% of total eligible voters to start one, and then majority rule, there was no minimum threshold, but the results of a referendum could be repealed by a subsequent special election or by a 3/4 majority vote of tribal council. That is what 2008 said, just so people know.
That sounds.
I don't
Mike
think
just said that
I don't think
sounds
that's
messy.
I don't think
I
that's very
agree.
clean, but it was kind of a hybrid of multiple things. But it was majority rules with the caveat council could come in and overrule the majority anyway with enough votes. So
All right, let me go through what's been proposed at this table, and we'll see if anyone wants to add to that. So Aaron proposed option 1, which is 30% of referendum ballots have to be returned compared to the total votes returned in the last chairperson election. So is everyone clear on that? Option 2 was proposed by Tyler, and that option is you have to have referendum ballots returned at equal or greater percentage to the total votes returned in the last chairperson election. So for option 2, for the referendum ballots, the percentage has to be equal or greater to the number of ballots returned in the last chairperson election. So if 10% of people participate in the last chairperson election, 10% or more have to return their ballots for the referendum election for it to be valid.
And then just go with the majority?
Then you go with the majority, yep. So you have to have the same participation level as in the last chairperson election. And then Rob's option is there's no minimum percentage after the referendum is initiated to validate the referendum.
So are you going to poll 1, 2, or 3?
I'm going to, so Aaron, you still want your option on there? Tyler, do you still want your option on there? Tyler? Okay, Rob, do you still want your option on there?
Yes, but I'd like to mirror mine to what Ryan stated was in the 2008 draft.
Okay, so that's gonna change it quite a bit. So,
Well,
Ryan,
it's
could you explain that?
5% of those that participated in the previous election, majority rules, and can be overchanged by 3/4 of a vote of the board.
He's revisiting the number of signatures. 5%.
So I think what you're talking about is the amount to initiate it, and we've already kind of moved past that a little bit. So now we're talking about how many need to be returned to validate it. So Ryan, could you expand on that?
The second part of what Rob just said is accurate. So it's once the referendum election happens, it's majority rules. It's binding, except it can be overruled by another special election or by a 3/4 majority vote of the tribal council.
Okay, let's pause this for a second.
Okay, then in that case, just remove the can be repealed by 3/4 of the majority rule. I'll stick with my original, where it's just majority rules after the threshold.
So you'd also have to remove the special election can overturn it too. Like it adds 2 layers that can overturn what the citizens want.
Yeah, 2008 had 2 layers that could overturn.
So number 1, the board could authorize a special election.
Yeah,
I don't really know what the
I'm
point
with
is.
you.
If you have everyone registered anyways, you'd just be doing a redo. And then do you want the
Right.
board of directors to be able to overturn it with a 3/4
No.
vote? Okay,
No,
all right, so we're gonna,
just leave it original.
okay, go ahead, Aaron.
I think this is important. I think the reason why the committee put that the board could repeal is because there was a tactic that was used by the administration of the tribe at a time where when we went out and got signatures to overturn a decision of the board just played a little game and just rescinded that resolution and then came back and wrote the resolution with like one word different and then passed that and played this game with the people where they were getting signatures to overturn the decision, and it was like hide the whatever. Yeah, the shell game, hide the shell, playing a little game with the people and violating their rights. So it is confusing to me. I think that's probably the only reason why that is in there. So I think that issue needs to be done separately from the decision factor we're doing. If we want to decide something about how to undo a referendum, let's get through how to pass a referendum first.
Yeah, it was probably an attempt to not, for lack of a better phrasing, not stick the tribe with maybe a law that no longer works 20 years later. So there was a way to undo something, but we can deal with that in a separate section if we need to.
So I'm going to explain these options one more time and then we'll do a poll. All right, so Aaron's option is this. To validate a referendum, you have to have 30% of referendum ballots returned compared to the total ballots returned in the last chairperson election. Is that clear? Tyler's recommendation is you have to have the same voter turnout in terms of that referendum as took place in the last chairperson election. So if you had 10% of ballots returned in the last chairperson election, you have to have 10% or greater ballots returned in the referendum election for it to be valid. Is that clear with everyone? And then Rob's option is there's no minimum percentage required to validate a referendum after you get sufficient enough signatures to initiate it. Okay, is everyone clear on that? Okay, Kim Lee.
Can we add the 2008 draft option as well to the end of that?
Okay, if that's the case, we're gonna have to have Ryan explain it because it has multiple layers. So we'll do an option number 4. So option number 4, we've already polled how many signatures need to take place to initiate the referendum, which is 5% cast in the last chairperson election. So that's number 1. Number 2, the board of directors can overturn that by initiating a special election and the majority rules in that special election, which seems excessive considering we have everyone registered to vote. So a special election, not a single person would get that ballot that who hadn't already received it in the referendum. Am I correct in that, Ryan?
Yeah, and
So
maybe
you'd
now.
be paying for an election twice.
And maybe now I'm getting too much in the weeds of 2008.
Yep.
Because it's not in our draft. But we as citizens had a way to initiate a referendum to create our own laws. And so part of that. Yeah, there's a right of initiative and a right of referendum. And so we had a way to call special elections as citizens in a different way than in this current draft. And they all kind of tie together. So taking like one small piece of 2008 may not work if we don't take some of the other pieces that go hand in hand with that. But
Well, and then the last part of that option is 3/4 of the board of directors can overturn the results of the referendum, even if it's overwhelmingly in support of overturning the board's action.
yes.
Okay. You still want it on there, Kim?
I do. I think all those layers were put in place for a reason, and I think that we need to not disregard that. Thank you.
Okay. Any questions on these? So we have option 1, 2, 3, 4. Lana?
Yep, my hand's up. Yeah, I think Rob said it earlier and kind of changed his mind a little bit, but Kim said it, and I do believe there needs to be an option 4 for that one too. Even though I said it, I was trying to get to that a little bit earlier, but was interrupted so many times, I gave up. But yeah, as long as that's an option, that's the option I'll vote for too.
And option 4, Ryan, would be the only option where the board of directors could overturn the will of the people in that election, correct?
That is correct.
Okay. Mike?
This is more of a point of order than I guess is how are we going to handle when we have 4 options and then say it's 3, 3, 2, and 2. We're not getting a very good majority of things. So can we narrow it down to 2 options with this poll and then poll again? Because I think with this being a constitutional amendment and with it being so important, I think we should narrow these options down, because when we get too many in front of us and it's all over the place, I don't think majority rules is a great one for
That's a
that.
good suggestion. So I can break this up in two polls. First poll could be option 1 and 2. Second poll can be 3 and 4.
I think you're gonna have to do all. The top getters, yeah.
So I'll poll on number 1, be yes, no. Poll 2, yes, no.
Well,
Do like
pull
that.
on all 4, see what you get, and then the top 2 from that, and then you vote the top 2 from there.
Yeah. Okay. Hold on one second. Kim Lee, then Isaac.
Oh, I'm sorry, I forgot to lower my hand.
Okay, go ahead, Isaac.
So what would be the reason to have a referendum if the board by 2/3 majority could change
3/4, I believe.
3/4?
Yeah. I don't know.
It would be minute, wouldn't it?
Point of information,
Yes, Lana?
just so I'm clear, that is what was in the original though, correct? The original 2008.
Correct.
That's correct. Yeah.
Okay, that's all I need to know. That's all I
Aaron.
need to know.
Yeah,
Question.
again, this notion of pristine, back to the original. The challenge with that, though, is if, ahead of time, if we know that the people don't like a decision that the board makes, they take the time to go out and get the signatures. We've increased the threshold from the original, but it's now lower than, no, it is more than current, right? Because it's 100 now, it'll be, maybe up to 350 later. And people go through all the time and effort of overturning a decision. If the boards, by a simple 2/3 majority, can override the will of the people, that's where we are right now. And that's why we want to improve our government, so that, we don't keep defaulting to, we have a representative democracy, you elect me for 4 years and you get what you get. If you don't like it, you don't have any recourse. The right of referendum was designed specifically to give people the right to challenge the decision of the board, if they make a poor decision or a bad decision. And I'll give you an example. The big boondoggle, either Greektown or use the developer, the latest developer lawsuit, 88 million, the chairman could overturn that. But if, let's say the people chose to overturn it, actually we did. There was a proposed deal with the developer who sued us for 88 million, and I went out and got the signatures, and we overturned that decision of the board. If we're saying now that 3/4 of the board could just vote to thwart and ignore the will of the voters of the tribe, I don't support that. I don't see anybody supporting that in good conscience. So I think the reason for right of referendum exists to overturn a poor decision of the board, and I don't think we should have a backdoor sort of pocket in our pocket how we can just ignore the will of the people by having 3/4 of the board vote to override a vote of the people. I don't support that at all. Nobody should.
Okay, so I don't have any names on the speakers list, so we're gonna do a poll. So you have 4 options. The top 2 options, we're gonna have a subsequent poll to figure out what the overall majority is, okay? So when Lana calls on you, just say option 1, 2, 3, or 4. Does anyone have any questions about what those options are? I can explain them again. I'm not gonna
No,
re-poll it afterwards.
Option 4 is the original committees, right?
That's correct.
Thank you.
All right, poll please.
Tyler. Tyler? I just let him back in a second ago. Sean? Lana?
4.
Isaac?
1.
Larry?
2.
Kimberly Lee?
4.
Rob?
3.
Aaron?
1.
Michael?
1.
Bridget?
4.
Kim Hampton?
2.
And Tyler, did you come back on?
2, can you hear me?
2? Yep. Sorry, I didn't mean to yell.
So what are the top 2
1,
options?
2, 3, 4 for
We can
2.
get yours, Austin.
I don't care. 1.
So it's between option 1 or 2 now.
Okay.
Yep.
Okay, so we're gonna do a subsequent poll. It's between option 1 and 2, and again, option 1 is 30, in order to validate a referendum, after you get a sufficient enough signatures to initiate it, at least 30% of the referendum ballots have to be returned compared to the total number of ballots returned in the last chairperson election. Clear? Option 2 is, in order to validate a referendum, you have to have the same voter turnout in that referendum as took place in the last chairperson election. So for instance, if 10% of people participated in the chairperson election, 10% or more have to participate in the referendum election, and simple majority in that election wins. Okay, we clear there? Okay, all right, so we'll do poll, just state 1 or 2.
Bridget,
2.
Aaron,
1.
Larry,
2.
Kimberly Lee,
2.
Michael,
1.
Sean,
2.
Tyler,
2.
Kimberly Hampton,
2.
Lana,
2.
Isaac,
1.
Rob,
2.
2.
Okay, the 2s have had it. So in order to validate a referendum, you have to have 5% of the people who participated in a chairperson election submit signatures. And based on the total people who voted in the last chairman election, if one were to take place today with this new amendment, if it passes, it would be about 350. And then to validate that referendum, you would have to have an equal amount of people participate in that referendum compared to the total people that participated in the last chairperson election or higher. So that's what we'll have in this draft. So with that, let's take a 10-minute break.
It's better than the
it again.
All right, so we got through right of referendum. Article 12, amendments. This language is from the 2008 draft, about 3 or 4 workshops ago. I can't remember now. It was a workshop Tyler was chairing. We put a pin in this at the time. This basically remove this, not basically, this does remove the secretary from it and allows us to do it ourselves if we want to amend the Constitution further. So keep that in mind as I go through. This is all new language. Section 1, request for an election. The tribal council may, by a 3/4 vote of the whole number of seats in the council, call for a special election to amend the Constitution. That's one way. B, the voters of the tribe may call for a special election to amend the Constitution by submitting a petition signed by at least 15% of the number of eligible voters of the tribe to the Election Commission. Once a petition is submitted, the Election Commission shall verify the signatures on the petition within 15 days, and if valid, the Election Commission shall conduct a special election within 90 days thereafter.
So I already have a follow-up question.
Yeah.
So with option A, in that special election, is there a minimum percentage of the ballots returned for it to be valid?
Nope. Section 2, requirements for approval. The Constitution may be amended by a majority vote of the voters who vote in the special election. Provided, the one caveat is that the amendment must be approved by a majority of the tribe's voting units. So like, I don't know, in some weird math, yeah, in option A or B, if an election happens, majority vote rules. There's no threshold to meet in this language, except the threshold is a majority of the voting units have to have approved it. So in some weird math scenario where a majority of our voters approved it, but only unit 2 and 3 approved it and units 1, 4, and 5 didn't, then it wouldn't pass.
So is that included further down in this thing?
What do you mean, Austin? Sorry.
So I might not be following you correctly, but it sounded like you said that simple majority doesn't always rule, because if you have a unit where the majority of the people don't support it, it could overrule majority rule, but I'm not seeing that in option A.
No, so option A is just requesting the election. So if nine council members, that's 3/4, right? 9 council members want to amend the Constitution, they get the votes in this version. And then it goes to an election. The election is run by our election commission, and then whoever votes, the majority say yes, we get an amendment. As long as at least 3 of our 5 voting units, the majority of those units also said yes.
I see, okay, that makes sense to me then, okay.
And same thing with B, if 15% of 39,000 petition for an election to change the Constitution, the election is triggered, and then majority rules. This is language that we definitely need to workshop. It's totally different than our current amendment, which is a secretarial election has that 30% threshold, right? But the request from the majority at the time of when this was last discussed at a workshop was to just leave this language as is, and then we're gonna talk about it at the table, so.
Aaron?
So, to make sure I get it right, so and here too, we have to decide 2 different decision factors. One is the threshold to compel an amendment via the members versus the threshold to approve an amendment. So if we stick with 15% of the registered voters, that's going to be 5,850 people would have to sign a petition to get that going. Now, I'm conservative when it comes to amending constitutions. I do think it should be a high threshold, but 5,000, almost 6,000 is almost as many people who vote in chairman elections. But if we did 15% of those who vote in the chairman elections to be consistent with the referenda, then it would be about 1,095 signatures. And that is not unreachable. It might be for somebody, but In different referenda that I've done in the past, 2 or 3 times I've submitted over 1,000 signatures. So I would lean towards the 15% of those who voted in the previous chair election versus 15% of the total registered voters.
The one thing I want to point out, though, with the way that this language is written, it would be easier to amend the Constitution than to overturn a resolution through a referendum. And that shouldn't be the case. You know what I mean? Like, if there's no minimum required votes that need to be submitted, you guys just polled that an equal or greater number of votes have to be returned in those referendum elections as the chairperson elections to overturn action by the board. So, I mean, the language doesn't line up to how their government should operate. So Tyler, then Lana.
I was going to make a similar suggestion to Aaron, but I was going to say somewhere between 20 to 25%, since an amendment to the Constitution is such a huge thing. That way, you know that you have to work to get a lot of signatures. I do kind of like the language that, 3/5 of the units have to agree. I think that's helpful because that way, unit 1 is the largest unit. If everybody in that unit votes and unit 2, 3, 4, 5 are opposed, like, that protects from something that might harm other outlying areas and things of that nature. But I was thinking, say along the lines of what Aaron was, but increasing that number to 20-25%, because it'll still reduce the total number of signatures, but make it high enough to where it is going to be challenging to make a constitutional amendment in that capacity.
Lana.
Yeah, this is just a simple question before anybody wants to interpret my opinion. This link, before we mark it all up, because I see we're marking it right now, the original language that was the original 2008 from the committee, correct?
Yeah, the original language that, take away my markups, I'm just like,
Okay.
I'm typing in as you guys are talking
Yeah,
to, just
yeah.
to make sure I
That's
follow the
what- yeah, 'cause-
conversation.
yeah.
But the original stuff I read through, that is from the 2008 draft, correct?
Okay, thank you.
So right now, the only proposal that we have is, if this is going to be a citizen-driven petition to change our constitution through a constitutional amendment, you have to have the signatures of 20% or higher of the people who participated in the last chairperson election. Am I interpreting that correct, Ryan?
That's what
Being
what my
proposed.
markup was based on what
Okay.
Tyler just said, correct?
Okay. But have we addressed how many ballots need to be returned for it to be validated
No, we haven't even talked about that.
with option 1? Because, I mean, you could have 3/4 of the council say, all right, we want to get rid of the OGMA, you know what I mean? Barely anyone participate in that election, and then, okay, you have one branch of your government just taken out, or tribal council, you know what I mean? So it should be difficult to change your constitution, and that's just where I'm coming from.
And right now, if we don't include this language, we want to deal with this later and not take the Secretary of the Interior out of it. We can also do that. We can just leave our current Constitution, that the only way to amend the Constitution is to call a secretarial election, do the voter drive through the BIA, get the 30% return rate, and then see where the chips fall. The recommendation from prior legal counsel, and I agree with this long-term at least, is it's maybe a good idea to at least talk about taking the secretary out of our elections. Doesn't have to happen right now. And in 2008, they recommended taking the secretary out of it. And that's what this language would do. And so we would have to run our own constitutional amendment elections if we have this or some substantially similar language.
Well, I stand by it, although you would have to have 3/4 of the council propose a, I don't know what you would call it, wouldn't be a secretarial election at that point if the secretary's out of it. But I mean, it would be more difficult to do a referendum based on the total number of ballots that need to be returned comparatively to changing our constitution, and that's backwards. Tyler?
Then I say that we just address it now. And I would like to see the secretary removed, especially if we have an executive, legislative, and judicial branch But let's talk about what that looks like. What does a safe number look like? So 20% is too low for signatures. Do you want to go to 25%, or do you want to say you want X amount of ballots returned in order for the amendment to count in either the legislative sending it out or the people sending it out?
You could make it.
Because I agree, we don't want it to be easy, but what does not easy look like? So you can't just rip out an entire branch of government like Austin had suggested.
So we've been talking about, basing, validating certain things on the number of votes cast in the last chairperson election. What's everyone's thoughts on, okay, for this to be valid, enough people have to participate based on the same voter turnout in the chairperson election. So if 5,000 people voted in the last chairperson election, if you get 3/4 of council agreeing to send this out, you have to have that many ballots or more returned for it to be valid, and then majority. Like, what are our thoughts there?
And that's about 18%, just to throw a number on it. It's about 18% coming back to make it valid, if we use that formula.
There has to be a minimum amount, though. I mean, it shouldn't be more difficult to do a referendum than to change our constitution. Aaron?
Yeah, I support a threshold of 25% of those who cast votes in the last chairman election to get signatures. And then the decision factor, I think, well, I really support 30% like it is now, because it shouldn't be easy to change your government, because we shouldn't follow whims. We get a wild hair this month and then we change it and then we change it. Government should be stable. So that's why thresholds exist. I do like the 2/3 of the units have to concur, because that is the way constitutional amendments happen in the United States. It has to be ratified by all the states. And that is a conservative notion to keep people from just, flip-flopping around in government. Government should be stable. So I think as far as taking the secretary out, I'm really, really uncomfortable with it. But I can get to a yes if we have a 3-branch. If we don't have a 3-branch, I can't support it, because then we have to entrust the legislature to make the right decisions. And in the past, people disagree with me, but in the past, I think there have been some hanky-panky with elections. And, the one example is, on an election night, there was a request for a recount. And then the chair of the committee publicly explained that she could not verify the ballot box was not tampered with. So I'm really nervous about going in-house on that unless the separation of powers is fully established in a 3-branch. Because here's the argument for it. The argument for getting rid of the secretary is because our current constitution, and I know some people like to believe it was, handed down by the creator and it's all traditional and everything, but it was imposed on us by the federal government in order to get recognized. That's why we have a board of directors and a chair. That's corporate America. It's not tribal governance. So, and we have to ask Mother May I. We have to ask the Great White Father. In this case, the color is not white. It might be orange, but we have to ask the federal government for permission to be a sovereign nation. And I think that I like the idea of not having to ask the federal government, but I also want to have the protections in place as a government before we do that. So if we're going in a 3-branch separation of powers, I can agree with taking the secretary out. If we're not going in a 3-branch, or if we go to the original draft that's on the agenda for tomorrow, I can't support taking the secretary out, because the safeguards that I want to be in place as a tribal citizen won't exist.
All right, so as it stands, there's 2 ways to amend the Constitution with this amendment. Number 1, the council votes 3/4 to authorize the constitutional amendment election. That goes out. Currently, there's no minimum return rate that has to be achieved to validate that. It's simple majority as long as 3 out of 5 units are in agreement with that. And then there's option 2, which is citizen-driven, and I'm going to write down everyone's proposals as options if we need to do polls. So Aaron, what did you state you recommended the percentage should be for the signatures needed to be turned in based on the number of votes cast in the last chairperson election?
So my recommendation for an option would be that 25% of the signatures cast in the previous chair election is the threshold to get an amendment.
Yep.
And then the threshold for approval should be. Ballot return rate. It should be, yeah.
Should be
I think
what?
that's a compromise.
Okay, so how many ballots do you think should be returned to validate something like this? And again, this is amending our constitution, which should be difficult to do.
Right.
So what would you recommend that return rate be?
I would prefer 30%, but.
30% of what?
30% of the total registered voters.
Okay.
Because here's the thing too, is that, some people might argue, first of all, I don't understand when people don't participate in their civic duty, right? I've voted in every election since I turned 18, but a lot of members in tribal elections have different views of that. They don't participate if they don't think it's gonna affect their lives. So that's why we have a lower vote turnout. We don't have a low vote turnout based on people who previously would register. We had a high turnout, higher than presidential elections for people who registered to vote. We have a higher turnout. But I do think if we're amending the Constitution, we shouldn't flutter around and be subject to fads or waves or politics and stuff. We should be a stable government that is planning for the next 7 generations. So I do think that threshold should be high, but that isn't what we just did with the right of referendum. But I think, I agree with Tyler, the threshold for an amendment should be higher than the threshold for a referendum. So I think we should stick to 30, but I would be entertained if it's 20 or 25.
I could support 30, to be honest with you. I mean, there should be overwhelming support, and there should be a lot of voter turnout if we're going to change our constitution. It should be something that matters to enough people that they engage. Kim?
I don't disagree with all of that. But on the other side of that, just flipping that coin over, changes to our Constitution, right? We've all known that there's been mistakes made in the past, not constitutionally, but so if we change the Constitution and the membership is not happy with the way things are going, because whether we like it or not, things change. And so should it also be unachievable to make things right, or to fix them to be whatever the membership needs, not so much how we have put them in place? Just some food for thought. I don't know. I think that protection was probably put in there because we need to make sure that if what we do needs to be changed, that it's possible to change it again. So that's all.
Mike?
2 things, I guess, is one, I think what got written right there on the requirements for approval isn't quite what Director Paymont was stating, because it's saying, it's going back to votes cast versus eligible voters. I think you were saying eligible voters because the Constitution amendment should be higher.
I was saying I could be talked into, because what the board just did was something completely opposite to what I would
Yeah.
like. They instead did a percentage of the vote cast in the chair's election.
Right, so I wrote both.
Okay.
Based off total votes cast in previous Ogama general election is achieved, or is it total registered voters? I have both
So
marked here. I don't
if
know.
you do versus total registered voters, that threshold is higher because you've already stated that in this last constitutional amendment, about 18% of the total registered voters participated, which was comparable with the chairperson election. So if you want to make changing the Constitution harder than electing a chairman, it should be based on the registered voters, not the people who are casting elections and casting ballots in those elections.
That's my
Mike?
preference, but I don't know if we're gonna get there.
I don't disagree with that. I do think it should be, the threshold should be higher for amendments. The problem I'm having, which Kim brought up, would be, is how do we weigh that because we're the ones who actually control registering this time too. It's not gonna be a BIA one where they send it to all the people and whoever registers, and then the percentage is based off of that, which would be a way lower threshold than what we're recommending. So I think 30 might be too high of eligible voters because we control the eligible voter thing, and if we're registering everybody, that makes it pretty high. But then again, maybe for a constitutional amendment, maybe it should be that high. So,
Could I say something?
yeah.
So I don't think the cost would be any different because currently everyone who's eligible to vote is registered. So the cost, even though we would assume the budget would be no higher than the recent constitutional amendment survey that we just had.
Yeah, no, I didn't say anything about cost. It wasn't about cost. It was about the threshold of the amount of voters needed to verify, to validate it. The BIA one would be way lower than what we're suggesting right here. What we're suggesting right here is 30% of what we register as voters, and that will be very high threshold. And as Kim suggested, is it attainable that we get 30% of what we are registering? That might not be attainable. Even for this amendment that we send this out to the BIA now, they approve it, they're doing their own registered voter list, and it's going to be much, much lower than what we're saying are registered voters. So that threshold number is going to be very significant in this, and I'm just going to state it, is that we're making a lot of these changes, and people are expecting us to know the answers by tomorrow. So something like this is a big deal. We can vote on it today, but we're not given the opportunity, we're not going to be able to have that opportunity to discuss this with the membership because this document is new. It's new to all of us. It's going to be new to all the membership because we have made a lot of changes, and I think it's a better document than what we've been doing, and I applaud everybody for working on it. I just don't think we're ready for it to vote on it tomorrow without the ability of the membership being able to weigh in on it one way or the other, and I don't know the right answer for this because I don't think we can survey them all. I don't think we can do all that, but this is a brand-new document, and we're going to need opportunity to discuss it with the membership. So something like that, I think we need to weigh in on it. I mean, we're going to do the poll and all that, but really at the end of the day, even if I get polled right now on that, if some members enlighten me on, hey, this number is just way too high and you guys didn't, take my thing into consideration, I would say I get bombarded by the membership saying, hey, you guys really need to look at that. So I just hope that we take that in consideration, I guess, within the next day, 24 hours.
Well, let's remember this. So everyone who's registered to vote received a constitutional amendment survey, right? So you had 18% return rate on just a survey. Not, okay, this is going to be binding, your vote counts, this is the end of it. So you had 18% of people participate just as their way of informing the board what they would prefer, even though they knew it wasn't going to be solidified. So I mean, if we're talking about dropping that threshold down for 30%, which is what the BIA requires, and you made a fair point, Mike, they do their independent registration, it's not based on everyone who's eligible to vote. I wouldn't drop it any more than 25%, because again, you had 18% participate in just a survey. So I don't think it's out of the realm to get 25. I mean, if 30 is too high, don't drop it below 25, because a constitutional amendment can do anything. It could get rid of every branch of government and just have a chief, one person makes all the shots. I mean, that's how drastic these amendments can change things, and you want it to be high. So, Aaron.
So what's on the agenda tomorrow night is two things. One is a wholesale rewrite consistent with what the Constitutional Convention Committee put forward, which surprises me because I never heard of that before a couple weeks ago. That wasn't even on the table. In fact, it was just the opposite of that. Several board members at the table that have been on for 20 years have said they will not consider a wholesale rewrite, that they wanted individual amendments. So that one's probably, that original draft is probably the least picked through and reviewed by this body than what we're doing now, because we haven't even looked at those issues. We haven't looked at large, we haven't looked at any of that. We decided to put that aside based on several board members who said they refused to consider a wholesale rewrite. So we'll see how they vote tomorrow, because if they support a wholesale rewrite, it will not be consistent with what they said we should be doing in order to get to where we are today. So that's number one. Number two is what the person who drafted the resolution is Isaac. And what Isaac drafted up and what we have in front of us tomorrow is to commit to a 3-branch separation of powers, because the vast majority, a landslide of the outcome of the people, selected a three-branch separation of powers. But he also provides in it specific timelines by which we would have to complete the rest of these intricacies that we haven't done yet. And so while I think we're ready to go tomorrow, I signed on to that draft because it is a very deliberative, very careful process where we can all go out and call people and ask them their opinion. We should have been doing that all along. I think from the day you're elected, you should be asking the membership what is their position on a separation of powers. And so it shouldn't come as a new surprise. Any of these issues should have been picked through, and we've had the opportunity to do it for, over a year and 4 months now since we voted to do the review. It's been a year and 4 months. So arguing for more time, I don't think is necessary. But I did sign on to going over the next month and a half to get to the point where these extraneous sort of decisions on the draft can be solidified. But make no mistake, the people, the vast majority of the people supported a three-branch. And again, let's come back to the argument that, well, that's not enough, that only a small fraction of the people participated. The percentage of people who weighed in on the poll is greater than the percentage of the highest vote getter in the largest unit. So in the largest unit, I won't name any names, but we're talking Unit 1, the largest vote getter got less votes, got about 16% of the votes in that unit versus 18% of the people who participated out of 39,000. Now, if you you can't really take the 39,000 and divide up by the unit outcome by the total number because they're not necessarily registered in Unit 1, but the percentage of people who participated in the poll was 18%. The percentage of people who supported the highest vote getter in the last Unit 1 election, the largest unit, got 16% of the vote. So more people participated in the poll to say they want a three-branch than people who elect the largest vote getter in Unit 1. Also, the percentage that participated overall is about the same, the total number is about the same as people who voted in the last chairman election. So the outcome is representative of what the people want. What more do we have to be told? It is representative to what the people want.
All right, so let's get back to what we were discussing. So right now, what we're trying to decide is how many of those constitutional amendment ballots have to be returned to validate the results. So Aaron proposed 30%. We can do polls, but let's get back to that. Does anyone else have any other suggestions?
Did we decide the threshold for signatures?
So,
Should we do that first?
yeah, we can do that. So what you're proposing is 25% or greater in terms of the amount of signatures that need to be
Austin,
collected? Okay, one
Austin, I
second.
had my hand up.
Yep, based on the total number of votes cast in the last chairperson election. So you're right, let's divide this up. And first we'll figure out how many signatures need to be collected for this to be citizen-driven. Because again, under this structure, you can change the Constitution with amendments two ways. One is a 3/4 vote of the council, and the other way is citizen-driven with them collecting signatures on their own. Lana?
Yeah, I couldn't hear everything that was being said, but, because there was no mic, but, I just want an option for the original, language in there. So that's all.
Okay. So we're working on the total number of signatures that need to be collected to start a constitutional amendment election. What was the recommendation from 2008, Ryan?
It was 10%. I had 15 in here. I think that was, I apologize. It was 10% in 2008. 15 is what the legal department changed it to, and so, but it was 10% of the total registered voters, 10%.
Okay. All right, any further discussion on this? We'll poll. Okay, so we're gonna do a poll, and this poll is just based on the total number of signatures that have to be collected for a constitutional amendment election to take place with the citizen-driven option. So option 1 is 25% of the registered voters have to sign, and option 2 is 10% of the registered voters have to sign.
Is the 25%?
I thought it was 25% of the total votes cast in the last chair election.
Okay, so that's different. 1 second.
So, Mr. Chair.
One second, let me, unless you're changing it,
I
Aaron.
am changing.
Okay.
Here's the thing, the only reason why I'm considering the alternate is because we just did something different on the referendum. But I'm perfectly in agreement with what the committee recommended, so let's see how this goes now that.
So
I
is
support it.
anyone opposed to that signature requirement being 10% of the total number of registered voters in the last chairperson election? Put your hand up if you are. Okay,
And
so,
that's consistent with the committee, correct?
yes.
Yes.
Thank you.
All right, let's lock that in, Ryan. Okay, so that brings us to the next item, which is how many ballots have to be returned in that constitutional amendment election to validate the results. So Aaron proposed 30% of the total registered voters have to return their ballots. Are there any other suggestions?
I didn't put my hand up, but I have to do it quick, so I didn't get there. The original 30%, Ryan?
The original was majority rules, provided that,
There's no minimum requirement, Lana.
yeah, no minimum requirement, but 7, because there was more voting districts. 7 voting districts had to
And
approve
just
it.
so I don't have to, just so I don't have to speak, I guess, and take up people's time here, anytime we have a poll, if you could just include, the original language, because we try to keep up and, the things are getting changed here, so poll and just say it's the original committee's language for a poll, please. Thank you.
Okay, option number 1 is going to be 30% of the total registered voters have to submit their constitutional amendment ballots to validate the results. Option number 2 is there's no minimum requirement of the ballots that need to be returned. And again, as I pointed this out, this would make it more difficult to overturn a resolution through a referendum than to amend our Constitution. So are there any questions about what you guys are voting on with option 1 or option 2? So again, option 1, 30% of the total registered voters in the last chairperson election have to return their ballot one way or another to validate the results, and at that point, whichever side has the majority wins. Option 2 is there's no minimum requirement of ballots submitted to change our Constitution. So last chance, any questions? Okay, poll please.
Are we doing that one or the signature threshold one first?
No one opposed the signature threshold, so that went unopposed.
Oh, I wrote down 2 options, so I'm really confused now.
So is anyone in disagreement that we should have 10% of the total registered voters sign on with the citizen-driven option to initiate? Okay, since no one's opposed, we're not going to do a poll on that.
Just, you go too fast, Austin. And that is consistent with the committee. We already determined that, right?
Yes.
Okay, thank you.
No objection.
Okay, does everyone know what they're voting on for this one? Number 1, 30% have to return out of registered voters to validate it. Option 2, there's no minimum requirement.
And option 1 would have been the committee's.
No, Lana, option 2 is.
Okay, good enough.
Okay, poll please.
Okay. Michael?
Option 1.
Sean?
1.
Aaron?
1.
Tyler?
1.
Bridget? 1. Isaac?
1.
Lana?
2.
Rob?
1.
Kimberly Lee?
2.
Kimberly Hampton?
1.
Larry?
1.
1.
Okay, let's lock in 1, Ryan, please.
And so I want to make sure I got this right. So 1 is a return rate of at least 30% of eligible voters.
Registered voters in the last chairperson election.
Yes.
And, okay, so I got that. So my next question for you all, am I keeping the language of from 2008 that the majority of the voting units also have to approve it?
Yeah, I think so.
I
Did you
thought
guys
there was
hear
no
what Ryan just
objection.
stated?
Yeah.
So you have 5 units right now. So as it stands right now, you have to have 25% of the signatures collected based on the number of votes in the last chairperson election to initiate the constitutional amendment election if you go citizen-driven. And then to validate the results, you'd have two parts. Number one, at least 30% of the total registered voters would have to participate that one way or another, and simple majority would win as long as the majority of the units were also in agreement. So it could be, you know how it would go, Larry? Yeah. Okay. Yep.
And I just want to add that that is consistent with the way the United States Constitution is amended. It has to be a two-thirds majority of the states having to ratify. We don't have states. So what we're saying is that through that election, two-thirds of the, is it two-thirds? Two-thirds of the, 3 out of 5 would have to validate the outcome.
And that is substantially consistent with the 2008 draft. There were more voting units, so the number's different, but the intent was to have a majority of the voting districts in 2008 also approve it. So this is consistent with 2008's intent.
So it happens to be two-thirds, or no, 3/5, but it's a majority either way. Yeah.
Okay, is anyone opposed to that? Okay, so we'll lock that into Ryan.
Okay. All right, we got through amendments. Article 14. This is our enabling article adoption. It's similar language that we have in our current constitution. So this amended constitution and bylaws, when ratified by a majority vote of the eligible tribal citizens, voting at an election called for that purpose by the Secretary of the Interior, because we're still using them for this election, right? Provided that at least 30% of those entitled to vote shall vote in such election, shall be submitted to the Secretary of Interior, and if approved, shall become effective from the date of approval. So it's saying, if we send this out to a secretarial election, and they do their voter drive, and 30% of those who register return it, and the majority adopts all these amendments that we're sending out, then they become adopted. It's the same language we have in our current constitution, and it's standard language in other constitutions for the secretarial elections.
No issues in your opinion?
No.
Okay. Okay, any comments, questions? Okay, so we can move on then? No, go ahead then, Mike. Yep.
I guess when it says effective from the date of approval, so the day that it gets approved by the people, we won't be ready to roll it out because we won't know how to roll it out until we see what's approved by the people. So then we'll have to scramble then to get, like, say, a good example would be is legal. Legislative will have their own versus executive will have their own. But the day that this gets approved, that ain't happening. I mean,
Right.
so we have no rollout time to actually incorporate what this entails. So, and I'm not trying to delay, it's not a delay tactic or anything like that. I'm just trying to understand that I don't know if we'll be ready for the effectiveness, like the judges too. The judges are, I mean, it says in here that those that are there now will just be there until we don't have terms on them. So we'll have a lot to figure out to still, I guess, I have concerns on how we're gonna do the rollout when this is saying it's effective immediately. And yet we won't be able to, I mean, we can plan and have contingencies, I guess, and that's on us to have those plans ready to go. Well, I guess I'll leave it at that.
I don't have a good answer for you, Mike.
I
don't
just
know.
wasn't sure if, like, it says we'll have, if we
Delay the
need it-
implementation.
if we need 60 days to implement the new constitution, would that be appropriate to put it here?
Yes.
Yeah, we can make the effective date like a future date. Like we could, yeah. I think that's maybe what Dr.
Yeah,
Payman was
and
asking.
I guess that to me would be more appropriate than us trying to figure out all these different contingency plans.
I just don't know I don't have a recommendation for you on what that date should be. So I'm interested to hear what others
60
think.
versus, I don't know, I think 30 or 60, but I don't think people are gonna wanna go full 90 or anything like that, so I think 30 is probably cutting it too, so I just think that needs to be addressed. I do think that it's gonna be hard for us to come up with all the contingency plans, but if it's effective immediately, I think we all run into issues right off the bat. So I don't want to set it up to be problematic on day one, but I do think that there should be some kind of days in there enumerated. We should put that in there. Yield.
Okay, Aaron, then Lana?
So it's a good catch, and the answer to that is when we approve the language for the secretary to amend the Constitution, we put an effective date in that approval. And I do think it needs to be probably 90 days, at least 90 days, because then we have to start rewriting code. I think that we can get to work on that immediately, not wait to find out what the outcome is and then have stars in our eyes. I didn't realize we had to do this. We need to get started on it now, and I think in the time that it takes for it to be scheduled, we should be drafting up what those code changes would look like, how much it's gonna cost, all of that. So the answer to it is that it's immediate upon approval, the effective date of approval. So we include in the amendment the language that goes to the secretary what the effective date of approval is, and we post that to be 90 days or 6 months, because it might be 6 months, so.
Lana?
Yeah, I was just gonna agree with Mike on that, but what Aaron stated did make sense. But I think as we go along, the only thing we should interpret that it's going to be passed and start working on it now, because even 30, 60, 90 days for this overhaul is gonna take a lot. So, that's a good concern. I mean, and I don't know the answer either, but we'll have elections to do we'll have all kinds of things to do, and we'll also have to have some money. So, those are big concerns. That's it.
So I've put in here a little placeholder, shall be effective within blank days. I made a note 90 to 180 maybe, to be determined once we have a better idea of the timeline, and we'll incorporate that into what is sent to the secretary. Does that work as a placeholder for now? We don't know what the timeline looks like yet, and we still, depending on what resolutions get passed tomorrow, we might have a better idea of our internal timeline to get some things ready. But this can be, put a pin in it until we know a better date, and then when it's time for a vote of the board to send it for an election, we'll insert that appropriate date.
We're gonna need time, obviously. I mean, there's gonna be growing pains, but we don't need to set ourselves up for failure. I agree with what Aaron, Mike, everyone's been saying. We have to anticipate that this thing is gonna pass if it gets enough votes to send it out to a secretary election based on the results of that survey. Out of curiosity, what did the Constitutional Committee say?
Effective immediately.
That's just not possible. I mean, it's
kind of whatever.
It's not possible.
I think it's what every constitution says, with the understanding that realistically, there's always a transition period.
Gonna be a
But I
transition
think I
period.
agree with you guys. It's better to just, let's put the transition period explicitly in it. It's not gonna harm anything.
Yep, I'm fine with that. Aaron?
Hey, the two attorneys that presented this did address that, and they said that when tribes are amending their constitution, they do put the effective date in the secretarial election. And so you can,
All right, so when we vote, it will show us like what the
yeah,
date is, yeah.
So, but the other good part of that, because they advised on this, they said, you need to put that in there because there are some tribes in the past who have not respected the outcome of the vote, and they thwarted it, and they end up in lawsuits, which they 100% have lost. The councils have lost that when they refuse to relinquish that power. They did advise us that everybody was all in a honeymoon stage when we voted to create the Constitutional Convention Committee, but they also said that once the legislature understands what that really means, you will have resistance. So, and they were right.
Okay, we can keep going, Ryan.
All right, so now we're down to our bylaws. We talked about this last time. I tried to incorporate some of our discussion. But Article 1 is meeting of tribal council. This language is substantially the same as our current constitution. Section 1, tribal council shall meet once each month at such place and time such place, time, and date as designated by the council at the meeting immediately preceding. The place, time, and date of the meeting shall be at the discretion of the tribal council, provided that at least one meeting per year shall be held in each of the 5 voting units. This is the minimum, right? We do this, in practice, we do this differently. You guys set your agenda out, and you can still do that. The tribal council can still do that. This is just setting that minimum threshold. Section 2, special meetings. Special meetings may be called from time to time by the speaker or the majority vote of the tribal council. Written notice of such meetings shall be given to all citizens, all members of the council, at least 10 days in advance of such meeting. At special meetings, the council shall have the same posture, that's a typo in our constitution, to transact business as at regular meetings. So the 10 days is a change when we pulled that last workshop, for 10 and 10 being the amount of notice. 10 days to the board and 10 days also to get the agenda out to the public. So that's why it says 10 instead of 5, and that was pulled last time.
Go ahead, Mike.
Are you sure it's posture, not power?
Well, I was trying to guess what
I think we've
the typo
discussed this
is,
before.
but
probably before
power would
you were.
work.
I think it was the same powers of the board meeting.
Powers is fine. Like say,
Power.
legal posture is like a term of art. You have the same legal posture to be able to perform actions in each meeting. But power is a better term, probably. Everyone knows what power means.
So for section 1, I know we jumped to 2, but for section 1, what we do in normal course is we vote on a calendar for the next year that transcends the minimum. So could we put that in the Constitution, that section 1 is time for meetings, shall have at least one in each unit, and shall be, and make conspicuously available the annual calendar that could go beyond that? Or do we just not even need to do it?
I don't think you need to do it that way. You can leave this as like the minimum and still continue practicing the way we are. I would say that aspect of how we're practicing is in line with our Constitution. So you could leave it and you could still do your annual meetings. Because you're still meeting once a month at minimum, right? And you're still meeting at least in one of the units each year. So you're still meeting that minimum. Even if you don't change it, you can still keep doing the way you're doing.
Yeah. One of the things that the council, the legislature will be faced with is deciding frequency of meetings and how often they want to meet. And what some tribes do is they don't meet weekly, they meet monthly for a week. They meet for a whole week straight. And then they're off the other 3 weeks unless there's a special meeting called. And the argument in favor of that is it's more comprehensive in the way that you consider legislation than piecemealing it like the way that we do it. We will address an issue at least 3 or 4 times before it actually gets to the board table. It's workshopped, it's brought up by the staff. And what's going to change significantly is the legislature is going to have a greater leadership role in establishing the legislative agenda, and then requesting to meet with the administration to bring proposals and recommendations and stuff. So that's all going to change. And what I've seen from tribes that have separated the powers is they don't do it as a weekly meeting. They do it more substantively based on all the different issues that have to happen. So this leaves it open for them to do it the way it's written. It leaves them open to do it however going forward. And again, it's not a free-for-all because the legislature is going to have to make that decision and vote on that. And if the people don't like it, they do have a right of referendum. I don't know if we're going to get to the right of initiative, but they did have the committee came up with a right of initiative.
Yeah, that's not in this draft at all right now.
So it'll be interesting to see what those people who say, we got to go with what the committee said, whether or not they still support the right of initiative. But the right of initiative was actually to give the people the ability to initiate something. Now, the people can initiate removal, the people can initiate referendum, but referendum is a approve or disapprove based on what the board enacted. So under the new draft so far, without a right of initiative, the people don't have the ability to bring an initiative forward, but they could bring an amendment forward.
They could bring an amendment, a constitutional amendment forward. They could do a referendum on an action already taken, but they don't currently, in the language we're workshopping, have any ability to bring a law forward.
So who took that out?
That was taken out. I had it in the draft that was presented 4 workshops ago, and legal was directed by the majority at that workshop to try to focus on just things that are needed in a separation. So the initiative is not strictly needed in a separation, and so that language was subsequently removed in the current draft. But I had it in there, I did have it in there in one of the drafts, so.
2003, if we go back and look at the record, in 2003, a group of members have been asking for a number of initiatives. One of them was term limits. Another one was for the people to be able to vote on the salary of the tribal council. I'm trying to think of, there was 4 items on the initiative, and it was called the right of initiative, even though it was it was intended to be a referendum until we told we couldn't do it. But we did have 1,113 signatures. I have all of that information still in a database. We brought it forward. The board at that time, which doesn't include anybody on the board now, the board completely ignored it and said, well, we can't do it because we don't have a right of initiative. But right of initiative vests the power with the people to be able to bring forward a request. Oh, the other one was a percentage of our casino revenues to go towards the land claims fund to buttress and support the elders' increases. So there was 4 of them. I'll have to go try to find. I have the original postcards that we did, but we did collect 1,113 signatures and submitted them, and it was just poo-pooed away. And that was before the committee spent a lot of time on drafting up the right of initiative. So again, it'll be interesting to see the purists that support the committee's recommendations to see if they support the right of initiative going forward.
And if something substantially similar to what we're working on now does go forward and does pass, because us as citizens, we have the power to do a constitutional amendment, if we get the required signatures, we could, we could get a coalition to do our own amendment, right? There would be a way to still get that initiative in, even if it doesn't get in this draft. Moving on, are we done with section 1? Aaron, was there another comment? Okay. Section 3, emergency meetings. This was discussed last workshop to make sure we had something like this in there. When immediate official action of the tribal council is necessary to preserve or promote essential interests of the tribe, the speaker or the tribal council by a majority vote may call an emergency meeting. Advanced written or verbal notice of such meeting shall be given to each council member to the greatest extent feasible. Emergency meetings shall be restricted to the urgent matter necessitating the meeting. So this would allow emergency meetings, even if you don't meet that 10-day window. If there's an actual urgent matter, you can, the speaker of the house, the speaker of the council, or the majority of the council members can call that meeting and get as much notice as feasible.
Mike?
If I recall when we were talking about this, I thought we still had a minimum even on emergencies, because I could foresee games being played with this too, because if there's no minimum whatsoever, if we were in a workshop and all of a sudden the speaker called for an emergency meeting and there was only 5 people there, 3 of them voted on something, I guess I'm not comfortable with just no time limit. If there's a 24-hour thing, 5-day thing, I do recall that there was a discussion of having the ability to do it. I just thought we had a date, like we had dates on that as well. So I do think it needs a date. I'm open to hear out what.
I don't recall if there was consensus on a timeline or not.
Yeah.
But we can try and get one now.
So what are you guys' thoughts on 24 hours? Does anyone object to at least 24-hour notice on an emergency meeting? Aaron?
I want to comment on the notion of it. So, again, without getting people all riled up here, is in the past, out of convenience, the board has made decisions to do special meetings, to have closed sessions, to claim it's proprietary, to vote on major decisions that people should have the ability for notice and comment on. So I think that, it's all in what an emergency is. If an emergency is, we got to make a decision real quick, or that, that $88 million liability is going to be $160 million liability, then I could support that. But in the past, I've seen this misused by board members that can get a faction to follow whatever they want. And then, and moving it from tribal council meetings into gaming authority meetings, that was a trick that was played often to be able to make decisions. Waiving sovereign immunity at the gaming authority level, where that should always be a tribal council level and not delegated. So I'm really leery about what emergency are we really ever gonna have that, that requires a 24-hour notice. I think one other thing that's gonna be different when we separate the powers is there will be some authority in the chairperson's office. I know what I've done in the past is if a decision was needed to be made, I tried to do a poll and say, well, we have money in a budget. How was this? For a poll, do we have a poll? Consistently, there's some board members who will never, ever give a poll or give their opinion, even when they're asked to do that. So I just want to be careful that we don't create I want to be careful that we create a conservative approach to be able to have and call special meetings for decisions to be made, so that the people their rights of notice and comment, their right of due process is not circumvented through crafty little tricks, so.
So before I call on Mike, what does the original document propose? Is there a minimum requirement as far as notice of these special meetings? And if so, how long is it?
The closest thing they have is special sessions, and it says it's the Ogama Power, it's different in our branch, or in our version, but it says, special session may be held in any district and date and location, shall be made by public notice. The purpose of the special session shall be explained by public notice. There's no time, there's no
But there has to be.
There's no timeline.
There has to be, otherwise you could be convening for a workshop, like Mike just pointed out, and the speaker says, well, I'm in a bad mood right now and I got a group of followers, special meeting, 10 minutes, we're selling off this property or something like that. Like, you have to have notice.
Yeah,
I mean,
the original draft had what Aaron brought up, had the council meeting the first week of every month for 7 consecutive days, and then the ability to call special sessions, but no strict timeline on them.
Okay, so before we go any further, does everyone agree that there should be a minimum requirement as far as the notice of special meetings? Okay, so I don't see anyone disagreeing. So right now, let's focus the conversation with the little bit of time we have left. How much notice should we give? So right now, for a board of directors special meeting, the minimum requirement is 5 days. For a gaming or EDC meeting, it's 24 hours. So it's whatever you guys decide, but Mike?
I think if we did it in conjunction, because sometimes 24 hours probably would have been helpful in some of the last cases, but to alleviate some of Director Paymont's concerns, I think if we did maybe a 2/3 vote was needed rather than just a majority, I think that would help. I say help because can it still be abused? Absolutely. We're not going to be able to prevent all of abuses in any of the stuff that we do anyways. But I do think if it's a true emergency, then if you can't get 2/3 of the council to say that it's a true emergency, well, there's your answer right there. Then there's no special meeting. So
Can the speaker in that scenario still call the special meeting,
Because with that way, you can do it 2 ways. Speaker can call it, or you're proposing 2/3 of the
or
people.
only council can call?
that's a good catch. But I think either way, the 24 hours is needed, absolutely needed. Abuse by a speaker of calling a 24-hour, if it's not really emergency, may still occur. And I guess at that point, there's ways to
Hold them
get it,
accountable.
hold them accountable. in this, where you could get different speakers that, hey, that he keeps on calling emergency meetings and they're not emergencies, and the majority of the council says, hey, we need a different speaker. So I think there's provisions in there to help prevent that as well, so I'm good with this.
Aaron?
I could agree with, I could get to agreement with two-thirds majority because it's difficult to get us all on the same page. But if that meeting happens, here's the other abuse that has happened over the years, is this game where the board in the past, and I'm trying not to be specific to any particular era, but this has happened and we know it's happened, so we can deny it all we want, but it's happened, is to claim that the decision that was made is proprietary, and then we don't pass the minutes. We wait 6 months or almost up to a year to pass the minutes. In that way, the people never get their right of referendum. They never get to institute the right of referendum. One very specific example, and again, nobody on this board was on the board then, but the chairman's salary at $856,275 annually was voted on in a workshop that was called as an emergency meeting. It was not on the schedule for that week. It was called the day before. And then the vote was taken during a closed session. It was never gone back out into open session to vote on it. And then when the people started asking for copies of the minutes or the notes, we used to record everything on cassette tapes. Lo and behold, the cassette tape disappeared. So we could never, ever get to what actually happened. And so, again, I know there's some on our board who will say, let the past be in the past. We don't have to worry about that. But if it's possible to happen, it will happen, because we've seen it happen. So we need to protect against, if we do have an emergency meeting by two-thirds of the legislature that calls it, whatever decision they make should not be held in abeyance or kept secret, to circumvent the right of referendum or the people to overturn that decision, so.
Okay, so as it's currently written, you can have a special meeting one of two ways. The speaker can call it, or two-thirds of the council can be in agreement to call it, right, Ryan? And then the notice is 24 hours.
Yeah.
Okay,
If
does
we-
anyone want me to pull something different?
Wait, I do have another question.
Go ahead.
So even with the two-thirds, how does the legislature make a decision to call a special meeting when they're not in a meeting? That's another, I think, a clear violation of our Constitution right now, because we do have the ability of 7 board members can circulate a resolution and do a consent by majority, and they're making a decision outside of a board meeting to have that meeting, and that violates the Constitution, because maybe the 5-day notice wasn't provided, and how do they take an action when they're not actually in council? Because the council has no authority if they're not in council, if they're not in a session. So calling a special meeting,
They need some,
How else can you get around it though, Aaron?
They need some
You know what I mean?
ability. Maybe it's,
High
So,
maybe it's only the
currently,
speaker.
like two-thirds of council would send their board administrator an email, all stating that they support a special meeting. And I get it, that's a decision and you can't make decisions outside this room. But let's say your last meeting was last month and you guys are meeting once a week or for a whole week. I mean, how could you do it? I mean, it's gotta work practically.
so one way to address it is if the legislature decides to meet once a month or whatever, you could have a set 1-hour legislative session on every Monday at 10 o'clock. And then you come together at that point, you're in a session. Then if there is a need for a special meeting for that week, you can call that special meeting while you're in office, while you're in a duly called session. The thing is, again, we got to protect against, because it's happened. It's major decisions have been made that way, where the people were then not allowed to even know about it because the board secretary would keep secret by not bringing the minutes forward. And until we vote on the minutes, they're not public record. So maybe it can be addressed in legislation. But I think, I'm just really leery. I don't support the legislature having any authority to make any decision outside of a duly called meeting, because that's what due process is. That's where representative democracy is. And it might feel convenient, it might be, luxurious and that we can just do whatever we want, but that violates the representation of the people. So due process is really important, and how you notice it, and when you can call a meeting. Maybe it's defining what an emergency is. So maybe we have language that references legislation that has to be enacted to legitimize what an emergency is, and then the legislature can draft that up. And if they go, far astray from of what that authority is, then the people could overturn that. Maybe that's the way to do it, but we don't want to go backwards, and we don't want to provide an opportunity. I don't support the legislature having any authority outside of a duly called meeting.
Are you okay with legislating this issue?
As long as there's
'Cause you
core-
basically have to figure out how you call a special meeting.
Yeah, as long
Whether
as
it's
there's,
last time you met, or, you make an exception, so you can
long as
email the
it's-
board administrator,
as
whatever.
long as there's core principles in the Constitution that doesn't allow for a free-for-all. And again, like I said, people can poo-poo it away all they want, but we've seen some really horrible things in our history where a group just gets going and somebody proposes something and followers just line up like lemurs and they say, okay, let's do it. And then we've made a major decision. We have waived sovereign immunity that way. We have excused people from liability that way. We shouldn't be about allowing that to continue to happen.
So a lot of this would need to be looked at with our parliamentary procedure code, right? It's gonna have to be looked at anyway, because one of the powers that tribal council has is to create their legislative process consistent with the amendments. So a lot of that is currently spelled out in that code and would have to be looked at again and spelled out maybe even more so in that code. But that all could be, we can say consistent with tribal law, and understanding that the tribal law is what's gonna govern, as long as we meet the minimum threshold of, if it's 24 hours, if what the majority agrees on, having that minimum in the Constitution, and then the rest should be probably fleshed out in legislation. So.
Okay, so do we want to keep 24 hours in at this point? And do we want to keep speaker can call the meeting and/or 2/3 of the council? And you guys can figure out how you call it later on? Okay.
Yeah, all right. Cool. Next section is open meetings, both regular, I added this just a second ago, both regular, special, and emergency meetings of the tribal council shall be open to the citizenship of the tribe. Make sure we hit all 3 types of meetings.
All right, I know of all the things, open meetings, it should be pretty easy, it's what's in our current constitution.
know.
But now that things can go to court, because right now, we can allow non-member participation in because it's in our parliament, our Open Meetings Act. And so we can allow non-members, but could potentially someone say, hey, that law violates the Constitution now, and they bring that to court? Because this part says it's only membership. I would hope not either, but
Oh, I see what you mean.
could
This
a
is our-
member
this
then
is our
prohibit it
current-
though,
This
Aaron?
is our current language.
A member could have standing and say, hey, I don't want non-members in any meetings whatsoever, and that violates the Constitution. They bring it to court, and then the court says, well, yeah, the Constitution says that. So I just wanted to make sure we're all on the same page. I agree that it probably should be, it's better associated in code, and that's where we have it in law. But I could also foresee someone saying, a member saying, hey, I don't want non-members whatsoever. I think that law violates the Constitution, and then we just let the courts decide. I'm okay with that too. I just want to make sure we're on the same page as that could potentially happen. And do we want to address it at all? We might not want to address it at all, and we'll let the chips fall the way they fall. And we just use the Open Meetings Act. I'm perfectly fine with that. But I just want to make sure that I'm understanding that correctly.
Yeah, I think your understanding is accurate. Yeah.
All right. I'll yield.
All right. Notice of meeting. All regular meetings shall be publicized at least 10 days in advance by some appropriate and effective means, such as newspaper, advertisements. This is all language in our current constitution. Radio, announcements, special meetings require such publicity as is reasonable Under the circumstances provided that all members of the tribal council receive notices provided in section 2 of this article. I'll make sure that is the right section, not we're changing things. Oh, come on. This teaches me to do global changes and not read it. So 10 days notice, special meetings, reasonable, but that shoots to section 2, but we should also, we need to reference emergency meetings. Must be noticed consistent with section 3.
Ryan, Lana has a question or comment.
Yep.
Good, Lana.
Yeah, and I know you're working on it right now, Ryan, but just to make sure, because in our code now states we treat emergency meetings like we do a regular scheduled meeting. So just that it has to be, I don't know if we need the language here, but that it has to be open to the membership.
Yeah, I got that in the section above this. I changed it so now regular, special, and emergency meetings are all open to the public, or open to the
Okay.
membership of the tribe.
All right, thank you.
Section 5, quorum, no business at any regular, special, or emergency meeting. If I can type. Shall be transacted unless a quorum is present, a quorum being a majority of the tribal council. This is all current language that we have in our constitution. Section 6, conflict of interest. No member of the tribal council shall cast a vote on any matter in which the council determines by a majority vote that said member may have a personal interest in the matter.
Aaron?
One of the weaknesses of this provision currently is that there's no requirement to disclose what that conflict might be. And it's also another significant problem is that it's up to a majority of the board to decide if that conflict exists. I'm not going to get into the examples, but there's been some pretty horrible abuses with not calling people in conflict. People voting on their immediate family, people voting on outcomes with relationships that are not disclosed. So we need either to promulgate an ethics code that requires disclosure of that, or in the Constitution, it needs to reference a requirement for disclosure, because the board can't vote on whether or not there's a conflict if the substance of what that conflict is. So again, I don't want to get into the details of votes that I've seen cast at this table where people absolutely had a conflict of interest. Officer elections was one. So
So you could leave this language as is and flesh that out in legislation.
Yeah.
And still be in line with this section.
yeah, I concur.
Lana?
Yeah, I could say a couple of those too. Let's see, what I was gonna say to you, Ryan, though, is, John Mornett did send a, legal opinion a couple of different times on the conflict of interest and the code that would determine how someone would have to disclose that. So I just wanted to let you know that maybe you could maybe you wanna look at it, just, we've had it a couple of different times, because this issue has come up, and it always, I think it needs stronger teeth for sure, but, and I think I have that around here somewhere. But he did send to the board a few different times what code and what responsibility it is, whether it was used or not, because I've seen some pretty strong abuses myself on conflict of interest. So that's all I'll say. Thank you.
And I have seen several different drafts of like an ethics code. I'm not sure if it was Wernett's draft or like one that was later amended, but we do have copies in our department of several different drafts. I know former general counsel was also working on one, so.
Bridget?
Yeah, as far as the conflict of interest, I wouldn't I would, I guess, be interested in legal having some sort of say in that, because just since I've been here, there's been votes that probably shouldn't have happened as well. But maybe legal being informed of those could bring, discuss it with the council as well and give their opinion.
Yeah, that could be something fleshed out in legislation as a role, or even not in legislation. The council's gonna have their own, I'll just call them a legislative attorney. You're gonna have your own council, legal counsel, whatever that looks like once we implement. And those are things that the tribal council can discuss with their attorney when the time comes, and how to implement that through an ethics code or otherwise, right? So,
Aaron?
So the problem, the first question I was going to say, who's council? The tribal boards council, legislative council, the Ogama council, the prosecutor. When this was first drafted, there was a solicitor general also submitted, proposed, so that laws that were violated by the legislature or the Ogama could be brought forward in an adverse action against them. And they need to be insulated in order to do that. So the problem with, if it's the legislature's attorney, is if you have a majority of the legislature that's going to cover each other's backs and excuse away conflicts of interest, then that counsel, whoever that legal counsel is that reports to that legislature, who can be fired by that legislature, is going to be reluctant to disclose or require an opinion about whether it's a conflict of interest. So what I think more often than not, what we've seen over our history is a reluctance for the board to call somebody in conflict because they're afraid someday they may be called in conflict. And so there's kind of like this good old boy backdoor thing where nobody gets called in conflict. And it shouldn't be up to a majority to decide whether to disclose a conflict. I think transparency needs to happen. I think the people need to see if there is a possible conflict of interest, that a vote happen in a public session so they can see how the council votes on whether or not there's a conflict of interest. Voting on your immediate family is clearly a conflict of interest. Participating, even if you don't vote, on issues that affect your immediate family is a conflict of interest. So right now it's wide open. It's been abused significantly. I don't know what Lana's referring to, but her argument is actually in favor of having some kind of requirement for disclosure and some determination made of a conflict of interest.
Lana?
Yeah, I'm not gonna get into that, but, yeah, I am in favor of having some stronger teeth in there, and I said that. The one thing I was gonna say, though, was gonna be a point of information. Aaron, did you say that, there was a solicitor general in the Constitution?
Yes, there was an original, when the committee was talking about how to hold the government accountable, that there be, I mean, you could
My
argue.
question is, did we take that out, or?
No, I don't think, did it?
I don't
make it in
remember
the
seeing
final?
that. I don't know if that made it into the 2008 draft, because
Well, that's
don't
important.
I don't remember.
We need to know if it made it in there or not.
Well, I have
mean,
it- I have
he
it right in
cited
front-
that, so,
I have it right in front of me,
Sorry.
and I will double check, but I don't see anything like that in this draft from 2008. So maybe it was discussed, but it was one of those issues where it didn't make it
Okay,
in.
well,
There was
yeah,
there was a prosecutor in here that was elected, but it was under the executive branch in this 2008 draft. So that wouldn't provide the separation that Aaron's referring to. So that must not have made it into the final presented version for
yeah,
whatever
that just perked
reason.
my ears, because he said that it was in there, and I was thinking, well, wait a minute, if it was in there, where did it go? It wasn't in there, they talked about it, because that's a pretty heavy thing, so I think I'm cleared up on that. But that's it for now, thank you.
Okay, we can keep going.
Where was I? Just section 7. Duties of committees, it's the same language. Do you want me to read through all the ones that are just the same language, Austin? This is the same language of our current constitution. We just submitted council instead of board of directors. Yeah? Okay, duties of all appointed boards, committees, subordinate organizations of the tribal council or employees shall be clearly defined by resolutions. Oops, typo. Of the tribal council. At the time of their creation or appointment, such boards, committees, or subordinate organizations of the tribal council shall report from time to time as required to the tribal council, and their activities and decisions shall be subject to review by tribal council. So this would, in the separation, this would take out probably a lot of the executive, stuff that's under the executive branch, but depending on how we structure the gaming authority, enterprise authority, some of those committees may still go right to the board, but that's all gonna have to be determined based on what changes we make to our laws. But the language can remain the same. It's all has to be done through legislation on who's under what chain they are. Section 8, monthly unit reports. It shall be the duty of each member of the tribal council to make monthly reports to the unit in which they are elected concerning the proceedings of the council. We do that now. Section 9, records. All ordinances, resolutions, and minutes of meetings of the tribal council shall be kept on file in the tribal office and shall, upon reasonable request, be open for inspection by tribal citizens at such office during regular office hours. Does Lana have her hand up, or I just saw it pop up?
Lana, do you have a question or comment?
I didn't, but I do now. That's the same exact language that we have now, isn't it? Or did we, did they-
Yeah, you're right.
Okay.
This is all the same language, just the highlighted is just clerical
Okay.
corrections, like changing board of directors to tribal council. And all these sections in our current constitution don't have titles. Like our open meetings section doesn't say open meetings. We added the titles to be consistent with the format of the rest of the constitution.
Okay.
But
Thank you.
the rest of the language is the same.
I thought maybe something was added for regular business hours, but okay, thank
No,
you.
that's how it's currently worded, yeah.
All right.
Aaron?
So I think that currently, and I think we've been pretty good about this, we've honored reasonable requests for records. I'll stop there. But that's a complete discretionary decision of the council right now. And I think that if we're putting it in the Constitution, I think it might need to have a little more substance, or if we're gonna legislate what that means, we need to have enough base language in the Constitution. So right away, one of the compromises over the years is you can make a reasonable request. In the past, we used to make copies for people, but they had to pay for their own copies. Or we would let you go and inspect the books at tribal admin. And when we pretty much gave unfettered access to people to look at stuff. But the way this is written, we're probably gonna end up in a lawsuit where someone's gonna say, you gotta pay for it. The tribe's gotta pay for it, because it's not clarified here. So I don't know if we wanna use language like a reasonable request at their expense, or, I don't know.
Brian, I
Yeah,
have something to add too. Just to back up a little bit, it mentions unit reports. Would there be a section in the tribal paper for the Ogama's report?
Yeah, we presumably yes, but it's not explicit in this.
Any objection to adding that? Seems pretty important.
Currently a requirement for us to do a monthly report to the members, which not everybody does. And the chair is currently a member of the council, so it would just be carrying forward that the chair
Just didn't
would be
spell it
able
out.
to do a report.
Yeah, I'd have to figure out where to put it. You wouldn't want to put it in with all these bylaws are geared towards tribal council, so we'd have to we could add it. I just gotta figure out where to add it. Maybe it's adding it next, there's already in the powers of the Ogama to do like a annual address to the Sioux Tribe Nation kind of thing.
Basically
So we
like
could
a
add
state
it
of the
there.
state kind of deal. But I mean, like if the legislative branch is giving updates as far as policy, things like that, it seems like it would be natural to also have an update on operations as well.
Yeah, I'll make a note here and we'll add it we'll add it to the explicit powers of the executive branch.
Mike?
I agree that, the Ogama should have it in here as well. To go along the same lines though, too, is that nothing in any of the stuff that we're doing, like the Ogama doesn't give the council any updates. Like, would be potentially be the, he's still going to be meeting with the other dignitaries, meeting with Congress, meeting all that, but we won't know any of that outcome. So I don't know where, granted, once a year, he'll address all the membership, and I guess we'll include it in that aspect. But nothing in here says anything about updates to us of consultations or anything. So it didn't occur to me until just now, until we're talking about these reports. So I don't know if it should be enshrined in the Constitution, but it's something that we should be aware of, that hopefully we all work together and that's not an issue. But at the same token, there's nothing in here that says that you'll give us updates.
Yeah, right now, I scrolled up. We have the express mandate, a power and mandate to prepare and present the annual tribal budget to tribal council. This is executive power. It's a little vague, maybe, to your point, Mike, but to keep tribal council fully advised as to the financial condition and needs of the tribe by preparing monthly reports for tribal council. And making quarterly reports available to the citizenship. So there is some language that covers some of it, and we can, if we need to tweak it a little, we can.
I appreciate that, thank you.
Maybe up here, Austin, is where I'll add just explicitly, like, the monthly reports can go in the newspaper or whatever. But you do have monthly reports that go to tribal council right now, but we can make it similar language for reports to the membership. Yeah.
Okay, Lana, then Aaron.
Well, yeah, because I wanted to correct Mike because, and I mean, that is one of the things that I didn't comment on in the executive, you moved it, but I didn't comment on in the executive authorities because I assumed that was a mandate in there. So if we have to make the language stronger, but I was satisfied with it, that the monthly reports to the legislation from the executive, and even vice versa. I mean, to be fair, that we'd make monthly reports as well on things, but so that back and forth on what's going on, so everybody is on the same page. But if we need stronger language for that, by all means, we should put it in there if it's not strong enough. But where is it here? If you just highlight it there.
I tried to scroll back up to it. It's this little I on your screen, if you can see it.
Yeah, I can see.
I added just a second ago, monthly reports for the tribal council and to the tribal citizenship, to Austin's point
Monthly
earlier.
reports to the, even written or something, yeah.
Aaron?
Just going to add that Little Traverse has an annual address to the membership from the chair, and I want to be careful about whatever language we put in the Constitution, that it doesn't imply that the Ogama is subordinate to the legislature, because they're not. Under the new structure, they will be elected separately. This has been a major bone of contention in the past, where the chairperson is interpreted to have been subordinate to the tribal council, and that is absolutely not what the people have ever thought. But
There's
demanding
also nothing in
reports-
code or constitution that makes the current chairman subordinate to the board. I mean, the board
Correct.
delegates certain things, and that's one thing, they can undelegate those things, but the chairman doesn't work for the board even with the current structure, otherwise the board could fire the chairman.
Right.
The board could suspend the chairman, kick the chairman out,
And we. will have to
It's a
go
member of the
further
board,
than
and
there.
it's not subordinate to the board any more than anyone else on this board is.
Yeah, and that's been a major bone of contention for some board members, because they perceive that they do control the chairperson. When the chairperson is elected by all people, and individual board members are only elected by their unit. So I just want to be careful in any language that we put here. I do think it's helpful for communication, but I don't think that it has to be the chairperson reporting to the council. The way it's written right now, it does suggest a reporting to the council. The chairperson should make a public report, a monthly report and a quarterly report on the proceedings of the tribe. Also, the legislature, I disagree a little bit. I don't think that the legislature has a duty to report to the chair unless it is legislation that will impact budgets, so that the Ogama can prepare whatever that looks like. And any reports that the legislature does need to be public reports, not secret reports or private reports or behind the closed doors stuff. It all needs to be transparent, out in the open. And if they're doing a report to the membership as well, then you have access, the OGMA has access to that. If the OGMA is doing a report to the public, the legislature has access to that. So we want to be careful about bleeding the lines and creating an expectation of subordinacy.
Lana?
Yeah, I don't want to speak for Mike here, but I don't think either one of us meant that whatsoever. So that's another way of interpreting what I was satisfied with that the OGMA would make monthly reports to the legislative for the purpose of finding out what is being said and what is being done based on the being the spokesman of the tribe. That should be done quite often, and definitely to the public. So I wasn't implying that they're subordinate, because this would be a separation of powers. But I need to know in a communication to make our government healthy and to know what's going on. And I even said vice versa, that the legislative could give the executive branch a monthly report on just a bullet of what is being done or what is being worked on. So I just wanted to clear that up, that I wasn't implying any subordination, and just wanted that on the record.
So I personally didn't think you were implying that, but as you know, board members have stated that in the past in this room, usually not while the camera is on being streamed to the membership, but it has been stated and it needs to be cleared up. The chairman of the tribe isn't subordinate to the board of directors. He's subordinate to the members that elect him, same as every single board member that sits here. You don't work for the board, you work for the members that put you in office, and you even work for the members that don't vote for you. So it's the same for my seat as well, so.
Well, and I'm talking moving forward. So I'm talking moving forward in this document.
Yep. Aaron?
Yeah, and I wasn't implying that either you or Mike were saying that. What I am saying is my input on the draft constitution has nothing to do with who's sitting in the seat now, because you're not always going to be sitting here. We are writing a constitution that should transcend any political faction, any individual who's in office today. And the I used to say this to the board, and I know they would get really mad at it, is when I was elected chair, when I was elected a unit rep before, is often other units would bitch and complain about how I did my job. And I'm like, look, you don't even vote for me. Well, why do I care what you think? You don't vote for me. The people that vote for me are the ones that put me here. And the same is true for the chairperson. When the people vote for chairperson, the chairperson or OGMA is in a unique position to have been elected by all the people, to represent all the people. Now, you can make the argument, well, we all should be representing all the people, but we know that doesn't happen, not all the time, not consistently, not by everybody. So I'm saying, just to be very clear and unequivocal, as I'm not implying anybody is doing anything, I'm saying that our Constitution needs to be above interpretation, so that somewhere down the road, someone can say, well, the chairman's not sending us a report, let's bring him up on charges. The chairman has no duty to the legislative branch under the new structure. The chairman is independent of the legislator, and that is what the people want. They just told us that.
I don't think, we'll double check, right? I'll go through this once we've gone through our first pass. I imagine, especially if the resolution tomorrow for the deadlines passes, there's more work to be done on this, but we're getting a nice draft going, right? That's not implying that any of the branches are subordinate to each other, and I don't think that's how it's worded now. I feel pretty strong in the current wording that even if we say that the OGMA has a duty to provide public monthly reports and give them to tribal council, that in no way implies in the current language that tribal council gets to direct him. But we're gonna have to have eyes on all this again, right, and look through and see if there's more holes. But as it's worded now, I don't believe that. I mean, someone might try to make the argument, there's gonna be a lot of, no constitution is above reproach, and people are gonna test the bounds of our constitution. That's part of being a separated government. So we're not gonna be able to plug every hole, but the language we currently have, I believe they would lose that lawsuit if they tried to say that the council could control the OGMA or vice versa, so.
Mike?
Well, in reviewing the section that you had pointed out, I mean, it does say that OGMA is gonna give, reports to the membership as well. It says quarterly, but I think we could change that to monthly in line with what you do, or leave it at quarterly. That, I guess that would be up for us to decide, but
That sets a minimum, so you could always do more, right?
yeah, you could always do more. The other token, though, is that you had said, you mentioned public. Now, I think those should be public. If he's gonna be reporting to the membership, those should be public. Ours, reporting to the membership, are public. But there's also gonna be some cases where it's not, we don't want public reports from the OGMA to the council. There's gonna be times where if he's running into legislators that aren't supportive of this, he's not gonna wanna publicly put out, hey, guess what? The legislators that I've met with aren't supportive of this, we need to come up with Plan B. There should be, that mechanism right now as worded covers that. It says that you'll give us reports. I just wanna make sure that we don't put the word public in front of his, on the OGMA's to us, to the council, I guess, because to
Right.
the membership, sure, public, but to the council, I think there's gonna be a lot of times where it shouldn't be out and made out in public because we are dealing with stuff and that when we make an action on it, yeah, that's public information as we need to be informed, not necessarily needs to be all public information, so I just wanted to make that distinction. Yield.
Lana, then Isaac.
Yeah, and I don't wanna, rehash all of this in the executive authority, but that was a big thing for me, that there'd be some kind of back and forth communication, cause somebody said it like a million times, and I'll say it the 1,000,001, is we're not all gonna be here. So if we're trying to make a better government, communication is gonna be a big factor between all of the branches. Executive, in my opinion, being the highest one, pretty much, that's my opinion, that a monthly report on what the executive is speaking about, based on our government, no subordination, just an expectation that there'd be cross communication, and I say cross, so legislative as well, maybe the executive, because maybe all three branches are gonna get along someday. Maybe they'll get along right after we approve this. But in looking for the future, I was satisfied with a monthly report. I don't know if it's in the legislative, I can't remember, but it was a thing for me that I read and seen that I thought it was a good idea. So, if he's out there advocating for, the tuition waiver, he met with, this person or that person, that's a very good thing, because then the legislative can communicate that as well. So, yeah. Just
Isaac.
want to say it.
Hey, I think all
Thank
the
you.
information should be open to the public, because no matter if we're in closed session or not, the information's leaked out anyways, so why try hiding it?
Okay, ready to move on, Ryan?
Except for there's times where all your attorneys at the government level are gonna need to be able to speak freely
Ryan,
without
you
it being
know it gets out
broadcast.
there. Seriously, come on.
All right, let me get back to where we were. Sorry. All right, so I added to section 9 whenever my screen catches up. This goes to director payments kind of question statement earlier. Article 3 of our bylaws talk about tribal records. So for this section, we can say this has to be pursuant to Article 3 of these bylaws. And then if we need to change something in Article 3, that's where it's very explicit how the citizens of our tribe get access to our records. So Article 2, duties of tribal council officers. Section 1 used to be the chair. Chairs will no longer be part of the tribal council, so speaker is the one that shall preside over all meetings of the tribal council and exercise any other lawful authority delegated to the speaker by the tribal council. The speaker also has a few enumerated powers up above in the legislative section, but their main power is to run the meetings, setting aside the ongoing discussion on speaker performing any roles with the OGMA, which currently they're not. Section 2, absence of speaker. The other officers pursuant to established parliamentary procedure of the tribal council shall assist the speaker when called upon to do so, and in the absence of the speaker shall preside at all meetings of the tribal council. When so presiding, the other officer shall have all the rights, privileges, duties, and responsibility of the speaker. Treasurer. Just didn't change much, but treasurer shall, under the direction of tribal council, conduct all the fiscal affairs of the tribe. The treasurer or a person designated by the tribal council shall accept, receive, receipt for, preserve, and safeguard all funds in custody of the tribal council, whether the same be tribal funds or special funds for which the council is acting as trustee. The treasurer shall be bonded in an amount to be determined and furnished by the tribal council, and shall deposit all funds in financial institutions as directed by the tribal council. The treasurer shall make and preserve a faithful record of such funds, and shall cause to be reviewed internally at least once every 6 months the books of tribal funds, and shall in writing report the results of this review to the tribal council. The treasurer shall, when called upon by the tribal council, give a status report on the fiscal condition of the tribe at any regular meeting. Once each fiscal year, the treasurer shall cause the tribal funds to be subject to an independent audit. The treasurer shall, in addition, be party to each and every transaction of the tribe involving real estate, and shall not pay out or otherwise disperse any tribal funds except when properly authorized to do so by resolution and ordinance duly adopted by the tribal council, which ordinance or resolution may be of a continuing nature and countersigned by the speaker.
Go ahead, Aaron.
So in the past, we've had a weak form of treasurer, and in the past, we've had treasurers who have performed their duty more consistent with the constitutional expectations. We have different codes that do place the treasurer on certain committees, investment, audit committee. Should we reference in the Constitution the treasurer's authority there? Because otherwise it's left to the discretion of whoever's in office to do their duty, or left to the council to let them do their duty, and it shouldn't be that way. So I'll just say this, and you might say it's blowing smoke, but we do have a treasurer currently that does perform duties consistent with the Constitution, but I think that there's even more authority in the Constitution for the treasurer's responsibility that is not practiced.
Yeah, because it's been delegated right out over the years to staff perform a lot of these functions, right?
Mike?
Well, then to touch base on that, though, if we're currently not doing this, all of this, I don't believe we are, isn't this our opportunity to correct that, the stuff that has been delegated out by law? Shouldn't we remove it from this part versus having it be a constitutional requirement? Because then someone could technically bring a court case up to the treasurer saying, hey, he's not fulfilling this, this, and this of the duties. And if we've delegated out by law to somebody else, he can't just take them over. The law doesn't supersede actually the Constitution. So we're going to go right straight into a lawsuit, I think, based on this, because if we've delegated those duties and if we are moving forward with this Constitution, if those aren't removed, then we're saying we want them back in there. I guess I just think that it requires further conversation than just, because my concern would be is immediately that there's a court case because we're not doing these duties, and I don't think these duties need to be in the Constitution. I think some of them should be in there, and the treasurer should have some responsibilities placed on them to report and be double checking the financial state of the tribe, but at the same token, being bonded and all these other things, if we're not currently doing it, and it's in our own current Constitution, and we adopt this, then I think we're going to lead to lawsuits right off the bat. So this might be an opportunity to clean some of that up. I understand why it wasn't addressed because we were talking about separation of power, but with the Ogama's office, they have an executive, a lot of this, some of it may be falling on the executive branch anyways, so is there a line being crossed between the executive branch and then these duties under treasurer? Because some of that seems to me like it's Ogama's office, like is the office of the Ogama should be
Right.
doing some of that, so.
And some of this stuff is being done
So
by
the separation of
government
powers
CFO
isn't,
and
yeah. So I guess my concern is the separation of powers isn't reflective under this current treasurer section.
You want to respond to that, Ryan, and then I'll move on the speakers list?
Yeah, I think you bring up a good point, and we, meaning the legal department, didn't do a deep dive into this part of the bylaws. We were much more focused on helping you guys get through the powers of the three branches. But I would agree that this it probably needs some work. I would probably agree with you, Mike, and I would recommend trimming this down to the very minimum of what the treasurer powers are, and leave the rest to be through legislation if appropriate, or through the Ogama's office if it's a law that's enacted and it has some fiscal bearing and it's under the government branch, then the Ogama on down, it's their duty to carry out those laws, right, and those duties. So I think this needs to be trimmed down a lot, probably.
Okay, Lana, then Isaac.
Yeah, I completely agree with Mike. My question was going to be, it looks like section 3 and probably 4. Section 3, that's just standard language that we have in the existing constitution.
Correct.
Is that correct, Ryan?
That's
Yeah.
correct. Yeah.
So the committee didn't even, they just said, okay, the treasurer duties should be these, or the secretariat duties.
Well, yeah, the committee got rid of the bylaws. The committee was a whole new constitution, and much of the bylaws got incorporated in other areas of the constitution. And we're trying to do we're not quite trying to build a new constitution, right? We're trying to do an amendment and insert what works into our current constitution. So, yeah, these bylaws were not, as far as I can tell, even contemplated by the 2008 draft, because it was a whole new constitution, right? So.
Well, we can't be asked to approve section 3 or section 4 when those duties go to somebody else, whether it's legislative, like Mike said, legislative or executive, and just put that in a constitution. That does have to be cleaned up and they have to be spelled out. Or any treasurer will end up in court or vice versa. The Ogama or legislative, we all could. Based on what this state's a duty is, and he's expecting someone else to do it, or we're expecting him to do it, and nobody's doing it. So yeah, I don't.
Yeah,
That's a hard swallow there.
and to be transparent with you all, right? This is part of why we didn't touch it too much. We wanted to workshop this. I am not even 100% sure, like what duties in section 3 still fall to the treasurer, or how much of them have been delegated out. And I think that's part of our ongoing work, and especially if we get the last resolution that's on the agenda for tomorrow. I think that's part of the whole analysis, right? And that part of that deep dive that needs to be done before we would send this. But I wasn't sure how to approach this without talking with the board, so we're coming to you guys first. So.
Yeah, because looking at this, as long as I can remember, and I've been here probably way too long, the treasurer shall, when called upon by the tribal council, give a status report on the financial condition of the tribe. That is delegated out. That's our CFOs to do those things. So.
And that is covered too, Lana, right? There is that fallback up here in the second sentence, that a person designated by the board of directors or tribal council in this version, right? So you all have, over the years, delegated much of this out, so it doesn't fall on the treasurer anymore.
Right, so it's sloppy, and I'm not calling you that, but it's sloppy for us to be asked on that when, if it's somebody else's, that's gotta be spelled out. This is a huge deal.
So we're redlining this whole document. This area is going to need some red lines, Ryan, right? Okay, Isaac.
Yeah, Ryan, being the treasurer for over 3+ years, my duties are pretty simple. You just go to the audit and tax committee meetings, there's not much else you have the authority to do. And a good example is I asked for a breakdown of the hotel enhancement funds that go out for each unit, and I was told that I couldn't get that information unless I had a majority of the board that agreed on it. So really, those duties are pretty much mute. I mean, you can't do anything as a treasurer unless you're in this meeting and you got full support of the board. The other thing that I do think the treasurer should have, right, it should be, they should carry one of the licenses with the state. And the reason I say that, we fired our CFO, right, on the casino side. If we would have got rid of our CEO on the casino side, we would have been out of compliance with the state of Michigan. So, you know, and people say that's far and few between, but that could happen again where we could not have a person. Or if those two people were in an accident and could operate, then what do you do? So I think that's one of the big things that the treasurer should be able to be licensed with the state of Michigan.
So you're gonna have to work on this, Ryan, come up with some proposed red lines.
All right.
I'm gonna move on to secretary after Aaron speaks.
Before you do that,
Go ahead, Aaron.
so when I was chair, what I tried to do to facilitate open communication was to invite the legislature to attend monthly financial reviews. Because when I was on council before, I will acknowledge that the chairperson at the time took horrible liberties on, well, to be specific, the board never voted on a budget, on an annual budget until I came to office. And I sat through budget reviews, which lasted like, I think, 12 weeks because the board got paid for every time they came together. So it was scheduled to be 6 weeks and it was 12 weeks. So they got twice as much money by sitting in. And then I asked a naive question, when are we going to vote on the budget? What are the budget priorities? How much do we have? And I was like, what do you mean? The board never ever voted on the budget. That didn't happen until we hired Bill Mattson to come in and draft up budget document 001, which was the appropriations authority. And so, and again, that's nobody on the board today, but I was not comfortable as a member of the legislature not having access to, like, how are we doing? How are we spending? We used to, before I became chairperson, we used to overspend, there are some board members that are on the board still, by $3 million a year, which is, I think, very ultra-liberal. It's wasteful. There was expenditures done in certain areas of the casino that never, ever came to the board of directors. The barge was purchased without any approval, any known written approval by the board of directors, and not a delegated authority either. So when we did set up financial reviews, board members never attended them because well, I don't know why, but I know that they couldn't control the process and some didn't like that. But the financial reviews were designed to create transparency in operations so the board could feel comfortable that the people that they delegate to operate are doing a good job. And they were doing a good job. Our staff do a good job. They have then, they still do. So I think there is a rightful role in oversight. Now, I don't mean micromanagement. I don't mean having them sit at the table and start barking out commands or asking the same question over and over and over. What does that program do when we enact those programs? And so we should know what they do, right? And should have confidence. So I do support that kind of transparency continuing. I know that, I don't know who to ask. Holly, are any board members attending financial reviews anymore?
Not the last few that I've been in.
Okay. But I do think that that's a good role for the legislature to play in a government oversight capacity as an observer. So I do support that. I do support the treasurer as a officer of the legislature having a level of authority to ensure our fiduciary duty is being honored. And that is not at all a second guess or a challenge on the OGMA's authority. Having uniquely, there's only 4 of us or 5 of us in our history that have had both roles, and I welcomed it. Nobody attended my financial reviews, but they were invited to, because that will dispel.
I did.
That will, that will dispel a lot of the rumors and a lot of the suspicion about the administration, because you get to see and you get the level of confidence that our team members, which are mostly tribal members, are watching the purse, they're doing a good job. So I do think there's a role for the legislature, for the treasurer to play, continuing, and I do think there's a legitimate role for government oversight for the legislature because they appropriate the funds. So I support keeping the language of the treasurer and not diminishing it, because why then do we even have a treasurer?
Okay, so we'll talk about this some more tomorrow. We have about a half hour left. Let's move on to secretary, please.
All right, I'll try to
Lana has her hand up. Go
put
ahead,
some
Lana.
language together for tomorrow too.
Yeah, and again, I don't want to diminish the powers of the treasurer. Wanted to clean it up so that they're not, some people have it in one of the branches and then the treasurer, it's an expectation of the treasurer and he can't get it. So, yeah, that I didn't want to do that. And Aaron, I did attend your financial reviews, and I always thought that was a very good thing that you did, actually.
Thumbs up.
All right, section 4, here's another one, right, I don't think we're in practice doing, the secretary of the board of directors is probably not doing all these functions, but.
A lot of them are done by the board administrator.
Correct, yeah.
Okay.
A secretary or such person as the secretary may designate shall conduct all tribal correspondence, including the notice of meetings. The secretary shall keep an accurate record of all matters transacted at meetings of the tribal council and shall see that all ordinances and resolutions adopted by the tribal council are reduced to writing in the proper format, and shall further see that a book containing copies of all current resolutions and ordinances is maintained and is accessible to all tribal citizens. Further, it shall be the duty of the secretary or such person as the secretary may designate to submit promptly to the appropriate office of the Bureau of Indian Affairs copies of all minutes of meetings to the tribal council, and copies of all resolutions and ordinances adopted by the tribal council.
Same as before, you're gonna need to do some red lines and just work on that and propose it tomorrow.
All right, Article 3, tribal records. Section 1, records of the tribe. All books, records, and financial accounts of the Sault Ste. Marie tribe of Chippewa Indians, including the tribal roll, shall be open to inspection by tribal citizens upon reasonable request to the tribal council. Section 2, records of officers. All books, records, and financial accounts kept by officers or employees of the tribe in connection with their tribal duties or employment are the property of the tribe and shall be maintained in the tribal office. Upon leaving office or employment, it shall be the duty of each tribal officer or employee to turn over such books, records, and financial accounts to the appropriate successor. Now, a lot of our details of this are in our FOIA code, right? They're not in our Constitution, but we've taken this article and we've created our FOIA code to implement it, so.
Aaron?
I would like to suggest, I don't know that we can do it in the Constitution. It's clear in the Constitution, the records that belong to the tribe belong to the tribe. We did have a secretary, not Kathy Abramson. We did have a secretary at one time who lost her election, and she was spiteful, and she burned a whole bunch of tribal records. Because she kept them at her house for some reason, and she had a big bonfire, and she just burned a bunch of records. So I would implore the legislature to draft up some kind of teeth to what the authority over the tribal records are. I know that each time that I left office, I scheduled for the executive and I volunteered to do this, and the law enforcement to be present for anything, including going into the computer. There are some documents circulating right now that that somebody had access to those tribal records that was not me. Those are currently out in a packet that's circulating. Several of you probably have been emailed about it. those belong to the tribe. I believe that's criminal, and I believe that the fact, when we just ignore that kind of stuff, depending on who does it, you know, if it were me, I can tell you I'd have been prosecuted. But those documents are circulating, and it really can only have come from one of two people in the tribe. The board principally did not have access to those documents, so it's not the board collectively. So I don't know, what I'm saying is, to me, it's pretty clear right here, but maybe the legislature should put some teeth together to define what not turning over those records would look like as a criminal violation, because they do belong to the tribe.
I've talked about this for a long time, like a non-disclosure agreement with elected officials, because I shouldn't be in a position to get voted out of office and leave in a disgruntled fashion and then take documents and mail them to people in different units and just try to put my spin on them to try to make the tribe look bad, or people who won elections look bad. Like people can see through that, you know what I mean? So I don't know what the solution is. I don't know if it's an NDA or we put something in our criminal code or election eligibility, but you know, your tribe's your family. If you're gonna try to hurt your family because you feel maligned, that's not okay.
Stealing from your grandma.
Lana?
We have non-disclosure, things that we have to sign now, at least I did.
We don't know. Nope, absolutely not. You have to sign a couple things when you come to office, but nothing like that. So I could theoretically compile all kinds of documents against the tribe and sell them to other tribes, developers, all kinds of things. There's nothing preventing people from doing it, which is why it's happened. And we've talked about it for years, haven't we, Kim?
Oh, well, I'm just saying, in the past, I have signed non-disclosure, agreements, and Aaron probably has too. Other board members, I'm not sure if Kim or Mike have, but I'm certain that we have in the past, so I didn't know if that was ongoing, because we have changed some things, but, yeah, I just want to make
Nope,
that comment.
it's a huge liability. You know, think of Enbridge, you know what I mean?
Oh, yeah,
Sell
I can
things to
understand
Enbridge and
that.
it's not okay.
Yeah,
Yeah,
and
we don't have a lot of teeth in that right now, Lana. It's something that over the years, like Austin said, that we've talked about it collectively as a tribe, and the legal department has off and on over the years tried to come up with different solutions on when documents are, you know, leaked or disseminated unlawfully. But we don't have those teeth right now.
we need a chain, and we also need a chain of custody when it comes to documents that we have within the tribe. So, and we don't have that. A chain of custody with a history of who has it and who's entitled to it, so that we can protect ourselves against those things as well.
You know, when
Because
Aaron Schlehuber became general counsel, him and I had a lot
I
of.
wasn't finished, but okay.
Okay, well, it's hard to determine that when you stop talking, you're not here. But when Aaron Schlehuber first became general counsel, him and I had a conversation about this, and he said it was a prevalent thing, board members leaking things, to the point where during the Greektown negotiations, they would distribute documents to individual board members, and then they would put itemized spelling errors that were just unique to each board member's packet, so they could see exactly who was leaking things, and they knew who were leaking things. I don't know if we need to go back to that, but it's sad and pathetic that we might have to, but maybe we do. Aaron?
Yeah, I don't recall having to sign anything at the tribal level. I do think when we were officers of the Greektown Management Board, I think we had signed something there. But Aaron will remember this, Aaron Schlehuber will remember this, because we did have a council member who leaked information to the Hannahville tribe, and when we were in litigation against the Hannahville tribe, and it leaked information about our Romulus development deal. In advance, it made the papers. Come to find out, that tribal member, who was also an attorney, was working for a law firm that was representing Hannahville. And he served on our board for 2 more years, and because he was part of a political faction, he was allowed to do it, continue to do it. When we froze the authority of the executive at Greektown to prevent them from cashing out more people, I'll stop there, because there's some people who got their contracts not based on any talent, but based on ability. And when the board voted to freeze the authority to pay out contracts, and then we litigated against the executive, I thought to, because every time that we met, somehow the defendant knew what we were talking about. So I looked at, and this is when the chair was not restricted, I looked at the cell records of individual board members, and board members were calling the defendant during breaks, during our Creektown Management Board meetings, and I suppose, I don't know what they were talking about, maybe they were asking about what the weather was like, but they were tipping off the defendant about our litigation strategy. And then the board voted to restrict the chairperson to not have access to any electronic records. That's why that exists, because I proved that board members were talking to the defendant in breaching their fiduciary duty, breaching their ethics. For whatever reason, we never did get to that. And so that is probably a really good argument, along with these documents that are circulating right now, the documents that were circulated from the chair's office, including trying to make you look bad, trying to make me look bad, but I read through them all, and I don't think I look bad at all, because I was protecting the assets of the tribe. But that's why an independent solicitor would be needed, and maybe the prosecutor's authority would be able to look into that. Another big one was $330,000 that was spent by the chairperson on personal bankruptcy proceedings that had nothing to do with the tribe. Legal counsel reviewed it. Legal counsel determined it had nothing to do with the tribe. But because of political factions again, the board chose to just let it go. $330,000 was put in somebody's pocket, and it was just ignored away because the political faction behind that person that did it did not see that it was valuable or an important thing to hold somebody accountable. That is a breach of our fiduciary duty, to just ignore that kind of stuff. And it's inviting it to happen again. So I don't know. We're talking about tribal records and protecting tribal records. The other big one is, if you learn if you're on this board, you have vote traded at different times maybe, you've got different political factions that you're in league with, and then when you leave office, we need to have something that restricts that person from being able to sell the tribal secrets or selling tribal records or selling votes on the board of directors. We have had, and when I say it, there's all this animus. Austin actually put it in his last article, that somebody from our table did financially, personally benefit by working as a contractor, and it's the truth. It's not a lie, it's the truth. And I know that I come under political heat from the majority of the board when I expose that kind of stuff, but it shouldn't be up to me to expose it. It shouldn't even be possible. So if we can think about how do we protect, and I think the records of the tribe include like plans for a development project, or legislative strategies, or litigation strategies. All of that should be under the rubric of the tribe's possession and ownership. And anybody that would breach that needs to have the full force of our authority to hold them accountable when they do that kind of stuff. Because it is wrong. It doesn't benefit the tribe. And if you're part of a political faction and you think it's funny that document's circulating out right now about Austin or about me,
I could care less, to be honest with you. Like, I'm a married man, I have a couple kids. There's 0% of me that cares. But what it does show is just sadness. Because even though I don't care and that's not harmful to the tribe, like everyone I've talked to said this is the stupidest thing ever. It reflects on the person that sent it. And it's not a mystery who did it. It could be damning to the tribe if it was a different type of document. And that's where the issue lies.
yeah, and my position is not so much that I'm hurt by it or offended by it, because I looked through it to see if anything I said was untoward or anything, and it's not. I was talking about locking down the assets of the tribe, protecting the assets of the tribe, not handing over authority to a king and creating a king. So I'm proud of that. I'm proud of what I wrote. But the problem is that we don't have any concern about that collectively, that can happen right under our nose, and we don't have any worry about it. The prosecutor should be investigating it, and because the possession of the tribe, those emails belong to the tribe. The person who leaked those should be prosecuted. But right now, the general counsel, well, the prosecutor should be separate from the general counsel, but has some ministerial oversight over the prosecutor. But the prosecutor should be free to be able to say, you know what, This it was stolen from the tribe. Whoever did it needs to be held accountable. They need to launch an investigation and hold people accountable when they steal from us. So if we don't do something to correct it, it will continue to happen. And someday you might be on the opposite side of a political faction.
So in terms of tribal records, this is something that we want to address, Ryan. I don't know how to do it. Obviously, there's limitations with our criminal code. You have to live on our reservation, but there's other measures. Certain people have pensions. They can be taken back. We've barred people from tribal buildings. There's ways to address this. There's eligibility requirements that can be modified for elected office. There's all kinds of stuff. But if you could look into it, I'd appreciate it. And I think most of our tribal citizens would as well.
Yeah, we'll add it to our ongoing list of projects for code provisions, not so much for a constitution. But yeah, we'll dust off the ones that we worked on in the past, and we'll put our collective heads together to propose something soon.
Yep, go ahead. Yep.
Just hearing you say that code, I wholeheartedly agree with you. It should be in code, not in the Constitution. But nothing prevents saying something in the Constitution that appropriate ordinances will be used to implement enforcement of tribal documents. You know what I mean? Something in the Constitution that actually states that. We've used that for elections. It says, hey, you'll do this there'll be appropriate ordinances to cover that.
Yeah, we have that language in other
spots,
instances above, so we can use a similar
I would
language
use
here.
a similar language here to highlight the importance of those of our tribal documents and assets.
Okay, anything else to go over this evening, Ryan? I think this is a
We
pretty good pause for the day.
We actually, there is nothing left. You all made it through, at least I don't know what pass it is. We've made it through this pass of the entire amendments and red lines.
Handful of things we have to circle back on, but, there's no reason to assume that it should take a terrible amount of time. I'm proud of this group. Isaac?
Hey, Ryan, can we get a copy of this so nobody can say that they haven't talked to their citizens about it?
Yeah, do you want me to, so I'll send you these red lines as they are now,
Absolutely.
and then I'll send you, I'll try and get some language together for these two sections before tomorrow. And I'll also send you a clean, easier to read version.
What I would suggest doing as well, we get here at 10 o'clock and we don't have the raise the hand war back and forth. If we just keep our comments concise and we don't debate each other, there's no reason to think that we can't be completed with this around lunch, maybe a little bit afterwards. This document's 16 pages. Let's take out the red lines when it's in its finalized form. Let's print them up, hand them to people that show up. That way they know what we're voting on.
All right.
Okay? All right.
Good.
All right. Have a good evening, everyone. I'll see everyone at 10 o'clock tomorrow.